Beautiful. So we should probably get started. So how many people want to introduce themselves but didn't get a chance to talk yet? Okay, well you should, be partly because you're one of our partners and sponsors and all around everything.
We'll keep this short and sweet. Hi, I'm from Open Law. I'm the product manager from Open Law. If you want to talk more to us, we're in the back. We're building kind of the legal protocol that's going to sit on top of the blockchain. We're also part of Consensus. Again, we have some great sticker swag in the back for you. I can talk to you more. And one of our legal engineers will be talking on the governance panel at 3:30. And we have a breakout session to talk about smart contracts and a quick demo at 4:40 if you're still around then. Thank you.
Beautiful. Thanks. Where is Emmerich? Okay, so we have a couple of announcements before we get into the program. Emmerich?
How you doing, everybody? So just a couple of things. This is the Bushwick generator. Many of you I toured last night. Some of you, there's some fresh faces here, so I haven't seen before. Just to let you know, like, everything is totally bootstrapped here. So hope nobody has any expectations of like anything crazy. We have generous sponsors, and we'll make sure there's pizza and stuff. I bought some fruit in the back. Bought some fig Newtons, you know what you didn't want to eat when your mom, wanted to shove them down your throat. So you should be able to get something. There's some cold brew. Otherwise, like I suggest, if you want to take a break and you don't know this neighborhood, go out to Say Coffee, go out to Swallow, grab a coffee, like enjoy, some time outside. At some point during the day, I don't know, when it works with the schedule, but if you haven't taken a tour of the Bushwick generator, I'm glad to set that up at some point during the day. So this is like probably 4,000, 5,000 square feet. The Bushwick generator is like, 100,000 square feet. In the future will be, upwards of 300 or 400,000 square feet of creative innovation hub. So back in that direction, I'll take you guys on a tour. As well, just want to introduce some of the community members. We have Ori here, who's leading the DAO initiatives, among other things. Also been very active in the community. Beth is leading a DAO. Yes, this is Ori. I don't know if anybody, do you introduce Jonathan Askin already?
Indirectly.
Jonathan Askin is a professor at Brooklyn Law, and he's been very active in this Bushwick generator community, and they provide pro bono legal services, which has been amazing. And Beth is running a DAO workshop upstairs. Are you going to introduce this formally?
Why don't we just do it now?
Okay.
I think your instincts are right on this. So, Beth, why don't you say what your workshop is quickly?
Yeah, so we have like a DAO prototyping workshop. So it's basically this design process. Then you'll see that upstairs for making like a minimum viable prototype for a DAO. So kind of working through the ecosystem, tokenomics, governance, and legal aspects of starting a DAO, and to kind of see, if that structure makes sense for like your project or organization, and just to understand more about DAOs in kind of an interactive way. So find me upstairs and Ori and like Daniel during the breakout session for that.
It's pretty amazing. When she says interactive, it's literally immersive. They've created a space like that you can walk through and think through blockchains.
So that's why there's no other tables for the other breakout sessions, but it will be all good.
Come on.
My name is Silke Al-Rifai. I'm the general counsel of Gnosis Group. I'm going to do a short lunch talk on how to get some DAO principles into international law. And I would very much hope that some of you join so we can write those principles together, and I'll take care to get those into international law later.
Here, here. And she's not kidding. She hangs out with people in The Hague and all kinds of great stuff. So, okay, perfect. And who are we missing? Going once, going twice. Are we all ready? Are we set for the live stream, Jolie? Well, we're missing Jolie. So Jolie's volunteering today to live stream this and help us with our audio setup. He's also part of New York ISOC, or ISOC New York, Internet Society. We'll be hearing more about ISOC and the relationship between legal hackers and ISOC over the lunch block. Okay, so with all that said, why don't we jump into the program?
I would consider maybe 30 minutes staggered from the actual schedule, so not too bad.
Yep, and we built a lot of fluff time into lunch. Okay, so to get started, we're going to begin with a kind of overview of what is computational law. So a lot of the action today is about blockchain. Blockchain is a computational system, but there's a lot more in the world of computation than blockchain. And most of what's happening with legal technology and transformation of the law to more of an information-intensive, technology-enabled field is happening with other kinds of systems, other ways to automate processes and other ways to deal with data. We're seeing a lot with AI and analytics and basic business transformation, re-engineering, using web technologies, databases, integrating systems. So what that means for the underlying context of law is sort of the subject of the first frame of reference setting session. And joining us from Kansas City Legal Hackers to help set the stage on that is Brian Wilson, who chairs KC Legal Hackers and who joined us at MIT in January to actually co-teach the computational law course that we do every year there. And so this is sort of the best of his first day overview of what is computational law. So Brian, welcome, and you want to introduce yourself and jump right in?
Sure. Hi, everybody. My name is Brian Wilson. I work in operations at a startup called Risk Genius, and we use different AIs to break down and quantify insurance policy language. And as Dazza said, I helped co-instruct the computational law course, and I also manage Kansas City Legal Hackers chapter.
Okay. Do you want to get us? Oh, hold on. I'm going to do starting the broadcast on our end too.
Okay.
Having two videos ensures at least one in my book. So okay, great. So sorry about the projectors. Yep. This is So everybody donate to Bushwick Generator. We'll get better projectors. Okay. I am now going to hit my application window, boom, share, present. Okay, do you see the slides, Brian?
Yes.
Okay. I'm sorry. I'm supposed to say a couple of things before Brian's slides. One of them is when we're transforming a field, in the beginning it might look like if you want to fly, maybe we need a mechanical bird, with flapping wings, because that's what we know from the past. But it may be some business process re-engineering is appropriate in order to achieve the results that we want, like something more like a fixed-wing airplane. So too with the law. Right now, thanks to Stanford Codex, there's a nice breakdown of what's happening in the legal tech market. There's a lot happening with dispute. You can't quite see it, but we'll make the slides available. But there's a lot going on with document assembly, with contracts, with online dispute resolution, practice management, predictive analytics. By my count, about half of what's going on in legal tech today is some form of automating existing processes and existing legal instruments, just making them digital and data-driven. And about half, and I think it's growing, is something that transforms law. So it's not the way that we used to do it at all. It's maybe model-based and depends upon chains of applications that transform the nature of the practice itself. So just as an almost ideological statement, what we really want to try to do with computational law is treat this information more like structured data and less like, my first slide, less like going from a parchment and making it PDF. Well, yeah, that's digital, but is it computational? Not really. Not really. Maybe you can scrape a little metadata off it. But here's an example of what what structured data looks like. XML has been widely applied to law. JSON is more the language of the day. And now, once things are more in structured data and expected formats, and according to some standards that can be applied across different boundaries and contexts, having interfaces like basic REST interfaces are critical in the law. This is not currently in individual applications or particular government agencies like the Federal Register support REST interfaces to interrogate their data or to integrate something. But ultimately in the law, we imagine and we suggest we should start to have more standardized types of interfaces and more expected design patterns so that we can integrate more and more processes and legal instruments in standard ways. So we can start getting more ecologies of automation. And once you do that, you can have listeners and triggers and literally start to connect processes so that they operate more and more in more of an automated way. And then we're going to explore, especially with smart contracts and blockchain, some things can in fact be autonomous. Everybody should use GET, the GET protocol. This is a theological statement. I will not go further into that. We should also express our data, and this is oversimplifying it, but think about it as 3 layers. Something that's human readable, a simple, plain language rendition that summarizes whatever the instruments are for lawyers and for regular people alike. Something that's lawyer readable, all of the terms and conditions and the nuances with indemnification or the particulars, and something that's machine readable, something that's more like data. So this is best practice, I'd say now, for expressing everything from statutes and regs to contracts and other legal instruments, and having a better sense in the law of what a how to display data, not only with dashboards and things like that, but also the user experience, so that it's more of a human-centered experience is going to be critical. And then finally, at the Media Lab, we think a lot about the implications of AI and autonomous systems. So one vision that a lot of people have is sort of like this. Who's this? C-3PO. It's an autonomous system. But there's another vision that we've really embraced at the Media Lab. We call it extended intelligence. And if I had to oversimplify it, it might be more like Iron Man. So now we've got automated systems, and including autonomous systems, the collision control and targeting and a lot of stuff in there, stuff that adjusts for pitch and roll, but it's extending the cognition and the capabilities of people. This is another way to look at how we can harness automation and autonomous systems, but where the role of lawyers and clients and policymakers could still be very central. And we need a stack, some kind of stack for the law. Okay, so with that, Brian, learn us about how to actually do this. So let's go through your slides.
Yeah, sure. So what I think everybody here is actually here for is trying to understand the different ways that we can compute the law. And so would it be better if I screen shared so that it can flow with the presentation? Or do you think that?
Come again?
Should I go to screen share so I can just click through?
Yeah, perfect. Okay, so you go ahead and take over the screen share.
Okay.
Stop my screen share. Start your screen share. We have a very perpendicular display going on here, so now it's a little bit like Hacker Noir.
Okay. So can you all see that?
Oh, hold on a sec. Boom. What is computational law?
Yep.
Okay, you're up.
Okay, perfect. Okay, so as I was saying, I think everybody here is kind of gathered to better understand the different ways that we can compute the various legal functions that allow our society to kind of operate at an optimal level. And so what does that look like? Michael Guinness Codex kind of came up with this idea that computational law is that branch of legal informatics concerned with the mechanization of legal analysis. And this can be done either by humans or machines. And in the paper where he kind of set this out, he likened it to having a cop in the backseat that can let you know about the regulations like speed limit, whether or not you're able to make a U-turn, and kind of really contextualizing the way that could look. And so, looking forward, there are a lot of possibilities out there. And so many of the lawyers and legal scholars and anybody who's kind of been familiar with legal writing will know this is kind of a structure that exists for like breaking down and writing about the law. You have an issue, you apply some rule to that issue, you analyze the way that that rule should be inferred based on the context around you, and then you arrive at a conclusion. With computational law, there's kind of a similar structure that we can derive. I don't know that the acronym necessarily flows, but you have data, you have all of these pieces of disparate information. You can input them into some sort of form that could be like Google Forms, that could be something like an expert system. It could be kind of whatever you imagine. After that, there's some computational layer that is applied, and then you arrive at some output. And so you might be asking yourself, what are all of these arbitrary things? How are they connected? So in the legal industry, this data could be static. It could be like the DC code up on GitHub. So it's got different laws or regulations. It could also be something that's live. It could be from an open data portal. It could be something that's interacting with an API. And then you put it into one of these forms that allows you to harmonize kind of these different layers that Daza was previously talking about, the BLT terms. You'll have your human readable, your machine readable, and your kind of like legal code there. And this is going to like necessarily require a higher degree of specification. So an added system like this is that it prevents lawyers from being lazy and forces them to actually specify what laws are supposed to do. Something that is really important for the internet. And with laws like fraud and abuse, it's kind of scary what happens with these sorts of things if you don't do that. Yeah, once you have that input, once you have that data and that input, you get to that level of computation. And so you have functions that automatically send emails, they automatically create records, they allow you to monitor compliance. You could even get into some of the more fun stuff like machine learning, AI, smart contracts, all the sorts of things that I imagine people here participating in the Computational Law and Blockchain Festival, these are the sorts of things that I think get everybody excited. So once you've done that, your data can be used in a way that allows the law to be more human. So you could have reports that allow you as a lawyer to kind of do your job more effectively. You could have some tools that allow you as a citizen to be able to navigate the process of getting your immigration papers filed, your divorce papers filed, whatever it may be. And this moves us forward in a progressive way. So going to get in a little bit into some vignettes that really drive these points home. So TurboTax has data about your tax filings. The user inputs that data into a form. This expert system helps you calculate your tax liabilities. Your state and federal tax returns are generated. With Do Not Pay, they have information about the ways that you might sue corporations. They have information about state and federal laws. That information is input into an application on your phone. They compute the amount of money that you could possibly sue for, and your claims are automatically generated. DLA Piper has a great global map of all of the data protection laws of the world that is interactive. If you get a chance, it's a really fun tool to play around with. But they have all this data about the global data protection laws. User can kind of navigate, drag laws to compare them and see, what's happening. Like if I'm a lawyer, and I've got a client who wants to deal with data in the EU, it might be helpful to see where the differences between GDPR exist with the laws of Canada, where we also want to market our product. And so you can automatically generate those reports and see the differences of the laws between the various nation states. Relativity Trace is also another cool tool. They have data about insider trading. They have a lot of data that they've collected about insider trading and compliance regulations. They monitor email communication in real time. They can flag suspicious activity and identify that for their security officers and their compliance officers, and then actually set up some dashboards to help visualize the areas where compliance and non-compliance are more easily understood. And so part 2 of this is going to look at Docassemble as like a really cool tool. It's an open source tool that allows you to set up some of these computational legal frameworks pretty quickly. And so Docassemble was developed by Jonathan Pyle. It's completely free. It's open source. It is based in Python, YAML, and Markdown. You can do a lot of cool stuff that is very beneficial for lawyers, kind of like the Iron Man suit for lawyers. It allows you to generate documents in PDF. It allows you to send faxes, among other things. And you can integrate with your file management system. You can set up chatbots that help your clients navigate to the services that they need more effectively. You can do all of this in GitHub so that you can collaborate with other lawyers all over the place who are doing sort of similar things. You can improve the best practices. You can come up with standardized ways of working on this stuff that makes the practice of law more transparent. And the way that you can do this is by deploying Docassemble. You can set up your own Docker container and run it locally, or you could use the great New York-based group called Computational Layer. They've got a ton of really cool tools that allow you to kind of go in and for free set up your own guided interviews about how to do this, and kind of an overview of the functions. These are those little pieces of code that actually allow you to compute the law. So as you can see here, it's not as intimidating as certain programming languages. You set up your question, you allow people to input their answer, and then you say, what sort of computation will be applied, and it does it. You can visualize that on the left. That's the infrastructure that allows you to get to the piece on the right that actually returns what you need. And so here's a list of all of the functions that are available. I'm not going to read through all of them because we have posted these slides on the page for the web page for this event. So feel free to check these out when you have a chance, and you can kind of learn more. All of the links are working. But yeah, you can take data. You can walk through this guided interview. You can generate advice letters. You can generate complaints for custody. You can generate certificates of incorporation. And if you ever have questions, you can collaborate with other people who are doing the same stuff on GitHub. Docassemble has Slack that's open for everybody. And I don't know if they're at this event, but Community Lawyer, again, is another great group that you can reach out to here. And with all of that, I think that's everything that I had. I'll hand it back over to Dan.
Okay, perfect. Thank you, Brian. That was awesome as usual. So before we move on with the program, let's just pause for a moment to see if there's any feedback or questions about all of that. So, and we can use the mic for questions. So questions are not mandatory. Oh, here we go. One in the back.
Two in the back. Great.
I heard you mention what I thought was a New York City resource called Got Lawyer, and I couldn't turn that up quickly searching. Maybe I misheard.
Did you hear that, Brian? Did you mention?
No, I missed.
Did you mention a resource called Got Lawyer?
I do not believe so. I can look it up real quick.
Sorry, so it was something you had mentioned for help in getting this set up, a type of community organization.
Oh, sorry.
What's the group that's doing the GitHub for doing Docassemble for lawyers?
Yeah, it's called community.lawyer. So if you just type into your browser the word community, and then you put a period, and then you type the word lawyer, it will take you there.
Come again? Oh, so we may have a community.lawyer named Mike here today. It's definitely worth checking in if you guys aren't familiar with Docassemble or the legal-facing instance of that with community.lawyer. Definitely get this onto your radar.
If folks are interested in Docassemble and Community Lawyer, we will be hosting on June 21st at Brooklyn Law School full-day workshopping on using Docassemble. And Community Lawyer will be very active. Community Lawyer essentially has built an overlay, user-friendly overlay on top of Docassemble.
And one of the best parts of this is the integrations. So that long list of integrations, some of those could be oracles or inputs or outputs from blockchain. Yes?
Thank you very much for the introduction to computational law. This is the first time I personally have learned the term exists. So being very greenfield here, please allow me to ask a rather simple, what I think is rather simple question. And if it is too simple, please forgive me. Who are the sort of main stakeholder groups in computational law?
So did you hear the question, Brian? Who are the main stakeholder groups in computational law? It's a good question.
The main groups that I'm familiar with, I mean, we're doing some stuff with the computational law course. All of that is available online. I know Stanford through Codex has a research group that's devoted to like computational legal functions. There are some different government branches around the world who are doing stuff with this. There are a handful of other groups I could pull up and add to the slides some of these groups, and I'll make a note to do that so that people can better connect with them.
Great. Also, something that comes to mind is the American Bar Association Legal Analytics Committee. It's got a whole cluster of people doing things. A long-standing group that's been around for decades is AI and the Law Conference. It's more academics, but that's a whole different stakeholder group. And actually, if you go to Codex and look at the index of legal tech, so go to Stanford Law or search Stanford Law, Codex, and Index, they've got a terrific directory of all the startups. So that's another stakeholder group of providers of tools and services and applications. And that's broken down according to kind of area of law and also type of technology.
Exactly. There are literally hundreds, if you go to that site, of legal tech startups that are in some way associated with computational law. I would also say that Codex, can't speak for all of Codex, but there's very much the opinion that this is kind of the next step in the evolution of legal practice. And obviously, different segments of computational law, the timing is different. It's not going to happen all at once. But anything from even, let's say, legal service, making that more of I would say, an egalitarian, more wider access rather than a privilege, right? Things like that. They're just very different kind of segment swaths that I would say converge in a lot of ways, and we expect more convergence in the future. So this is happening a bit behind the scenes, but also a lot of these legal tech startups are becoming more prominent, especially I would say in the Bay Area, where there's already kind of a tech infrastructure very much that's open to using these new platforms. So keep attention, I guess, see what's going to happen.
Yep, the Bay Area, and also geographically, I think we should point out Toronto is just a hot spot. It's a hub of innovation with legal tech, I think owing partly to outflow and collaborations with McGill, but I don't know exactly why, but it's the perfect storm of legal tech right now. A lot of startups, a lot of new ideas, Ethereum, among other great things. So, Google Street Labs. Maybe one more, and then we should probably. We're not that far behind the first panel, which you're running, Steve. Okay. Let's let this run for a while.
Hi. Thank you so much for that presentation. This is completely this has been a black box for me as well. So all this is so enlightening. It might be too early of a question, but what type of challenges have you guys personally seen, or do you guys foresee as we're kind of trying to adopt this new amazing technology? What type of challenges do you see in terms of adoption and sticking, for that matter? Because as we all know, there are many great technologies, but sticking is always kind of a different issue. So do you see maybe like, is it the matter of education? Is it because like a lot of people are kind of fearing what it is? Like that word computation scares people? Or is it a question of like institutions kind of continuing to do it their way and you don't see adoption there? Like what sort of challenges essentially have you seen in terms of adoption?
So the question, Brian, was what kind of challenges have we seen for adoption? And I could get us started. At a high level, one thing to bear in mind is that the law is obviously law is its own field, so we have training and regulation and licensure, but very much I think the overall context is law is part of, it's like marbled in every other sector of the economy and part of society. So when you look at commerce, or you look at industrial systems, you look at public sector systems, they're not primarily about law, but law is sort of one part of the stack, and maybe not the big decision makers on when do we choose to migrate to a new IT system and what are the priorities for those systems. The terms and conditions and things have got, exist, but it's hardly driving the design of the systems. I think there's also some reticence, or I think the law, it's hard to generalize, but the personality of the field is somewhat conservative. And so, the more conservative that the orientation of the sort of sensibility of the culture, the less prone it is to be an early adopter of new technologies, which, by the way, is not so bad. Being first to be second on some of this stuff can allow for more stable, reliable, predictable kinds of systems. Another thing is it's actually not obvious how the law would transform as a result of these technologies. So with air traffic control, it was pretty obvious. We're tracking the flights and, again, collision detection and routing. And, with factory automation, it's pretty obvious. With the law, there's so many facets of law, and I think most of how the law is going to transform has not yet been invented. So some of it is just figuring out as we go. We're sort of re-engineering the bicycle while we're riding it. And then one other thing is just what I was trying to hammer on for my own hobby horse, trying to do analytics and data science on law at MIT, is just so much of the corpus of the existing law is not yet really suitable for computation. That's why we're mired in natural language processing and other types of systems where we're like paving the cow paths or making mechanical birds. So starting like at the essence or like the DNA at the design phase of structuring our legal instruments and our rules and our processes so that they are like structured data that's computable is another barrier to adoption, I think. Do you want to extrapolate on that, Brian? You're very much in the front lines in your startup.
Sure. Yeah, I think one of the biggest challenges to getting things like this off the ground and making sure that they stick kind of in the way that you described was there really needs to be a degree of openness that a lot of people, I would say, aren't super comfortable with. I mean, looking back at how the internet was able to thrive, it wasn't really until they adopted the open standards of protocols that that you could really see the true potential of the internet to connect people, to allow people to share ideas back and forth. And I think with kind of these AI and computational ways of thinking, it's very similar. There isn't going to be the kind of the flourishing that is possible unless we really have it so that it is interoperable and people are able to kind of like whittle down these ideas with each other. And so to me that seems like a big challenge, but also moving the legacy providers away from using Internet Explorer. That's kind of like one of the things that I deal with on a daily basis is a lot of the biggest companies, especially, or speaking for insurance, a lot of the biggest insurance carriers in the world, like they mainly use Internet Explorer because of how risk averse they are. And so, until people are willing to do these things, until people have kind of like a playground where they can, experiment with these sorts of ideas in ways that prevents them from losing risk, and until people can kind of like audit and like reduce that degree of, opacity such that, people can understand and like see, okay, if I put this in and it spits this stuff out, that really is a good thing, and it's not sentencing people for unnecessarily long amounts of time because they're a certain race, they're a certain gender. And so I think being able to kind of actually experiment with these sorts of things scientifically is something that will allow it to flourish and like kind of maintain itself as a like cool innovation for how we move forward.
Yeah. So I think, why don't we take a couple more questions, you and then Brendan. But one thing I'd like to note on that last note that Brian mentioned, so the first thing he said, which is, I wish I had said in retrospect, was we need something more like open standards. And from open standards, like dominoes, many of the other barriers or inhibitors to adoption, I think, will start to fall that I'd mentioned. But the last thing he said is more of a scientific approach. So, one of the two words in data science is science. And so on that note, Brian and I and Jonathan and other people are banding together at MIT Media Lab from the Human Dynamics Group to launch on April 27th the MIT Computational Law Report. So it'll be sort of like a journal. It'll have articles, but the reason we're calling it a report is it's also going to have some rich media like podcasts and interviews, but also like a data playground. So what we're starting, you'll see on the submission button, one of the things you can submit is your projects or your or data science, and so we'll be looking to get the underlying data that you used, what the scripts or the Python notebook or whatever it was, and what versions of software you used, just so we can see if we can get reproducibility. Could we reproduce the same results you had, and that way have more of a scientific method applied to the underlying algorithms and the other types of software. This is some of why we feel we can rely upon science in other sectors of the economy. And when we have this type of rigor in the law using data science and other automation and methods, computational methods, then we may be able to have a more reasonable, a valid and just basis to use it for things like sentencing guidelines or like other very sensitive areas of law. But right now, there's understandable reticence to do that because it's still quite buggy. So the idea of introducing science methods into the data science of law, we really want to underscore, and we want to try to do our part at MIT, and we hope you'll all do your part as well. So two more questions, you and then Brendan, and then where's Steve? And then let's get into the first panel. Okay, so you're up.
Thanks. So it seems to me like the community lawyer and open law projects are premised on the idea that the benefits of open source philosophy map onto computational law and perhaps also the practice of law. And so I'm wondering whether the panel agrees with that premise, and if so, why?
I don't know if I understood the premise.
So the premise is that the benefits of open source software development and principles will also apply to essentially the practice of law.
Oh, I got you. Did you hear that?
Yeah, I think that's right. I mean, there's been the litigation recently with the information. I think it was with Pacer. They're charging too much for that, and it's really increasing the kind of like digital divide that has led to all of the access to justice problems that have arisen. People don't have the tools to empower themselves. It's like everybody has to go to a restaurant to order, their legal services when they could go to a grocery store and find tools and ingredients that they could use themselves to, solve their legal issue to the extent that they need it solved. It's kind of like a monolithic sort of world out there, and it can be more dynamic. And I think the openness, especially around the information about how the law is, like what the law is, how it's applied, I think that's critically important for moving forward in a meaningful way.
Could you pass the microphone to Brendan? And I'd extrapolate on that a little bit, which is with so you zeroed in on open source. I think there's 3 relevant open dimensions: open data. So in particular, things like cases or statutes or other legal information needs to express itself as a service and an interface. If it's your private data, at your firm for analyzing risk and liability or whatever, that's not necessarily open data, but a lot of the law it's supposed to be public. It's the quintessential public document, and yet it's not really accessible. Open source and the applications, I think Brian mentioned, but then there's also open standards, and that's where I think I think that deserves at least as much priority as any other dimension. So the more standards we have that are open at the messaging layer and the the interface layer and some structured data layers for different types of law, the much better off we'll be. And I do think that that's a premise for a wide-scale adoption of computational law. So it's going to be Jonathan. Brendan has the last question, and then we go to Steve's panel.
I actually just want to comment on the last question and the question before, because there's a big piece we're missing. How many are lawyers in the room? A lot of us. So we all know this. We are a fucking gilded profession. We are gatekeepers, and we will be damned to let other people use our tools for their own purposes. This is going to require more than a generational shift. To see Brian up here revolutionizing the law, he's 30 years old. It's going to be his lifetime mission to change the law, but it's not going to happen until he is a member of the senior class of the gilded profession. Openness is not, it's anathema to what the legal profession is about. We worked 10 years ago on trying to open up PACER. You know who our biggest obstacles were? It wasn't the Republican Congress, it was the ACLU. I was raised by the general counsel of the ACLU. I know and love the ACLU. But people from the ACLU told us, do not try to make PACER documents free. Do not open it up, because it will mean a $300 million shortfall in funding the federal judiciary, and we need to ensure a funded federal judiciary. That was their analysis. So essentially, we're fighting for closeness even among the liberal left attorneys out there. We are the trusted agents, and until we create perfect systems, the lawyers are not going to let that go. And even if you are an enterprising, ambitious, young attorney at a law firm, you still answer to that 60, 70-year-old partner. So until you are that 60 or 70-year-old partner, and until we have those open tools and acknowledge that we've now created better trust agents than the legal profession can provide, that's what we're going to be stuck with.
And of course, there's hope right now before you turn 60, because there already are rays of light all around the world. I just came back from Paris, a computational law conference. Many of us were in Beijing at a computational law conference last month. We mentioned Toronto and other things that are happening. So there's lots of little areas where the future is starting to sprout. And some firms are embracing it. Some small firms are fully born digital now. And there's more of a conservative adoption, as Jonathan was mentioning, but even in big firms like Allen Overy, Baker Hostetler, and others have done a good job with their CIOs and their partners and senior associates at adopting in certain practice areas. So I do think the future is beginning to, it's hard to hold back the light of dawn. So I do think it is happening. Brendan, you want to bring us home with your question?
Yeah, sure. Brendan Marr here. The question was about stakeholders. These contracts are going to touch everybody, every aspect of society, everything, nothing is going to be left untouched. But the way to think about it is that we're not going to have people just calling up their lawyer and writing contracts. It's not going to happen that way. What is going to happen is that you in this room are going to get paired up with entrepreneurs, and you're going to write the stuff on the back end of platforms to go out and touch and bring this stuff to billions of people. And that's how I believe it's going to happen.
All right, so with that exhortation, why don't we wind up our panel, and let's everybody thank Brian for coming in the morning. Thanks, Brian.
Thank you guys for having me.
Legal hacker, right there. And Steve, could you want to take us forward into the panel?
By the way, restrooms are there if you ever need. Again, feel free to take a break as you please. Our next session is Blockchain Compliance Today, the Q&A. In the spirit of the CLB Festival has been quite interactive. We decided that rather than have another typical panel, we just open up with self-introductions and then just go launch into Q&A from the start, so you can ask all your questions. Usual disclaimers, not legal advice, but consider it, personal opinions, guidance, things like that, to help everyone in the space, whether you're a lawyer working at a startup that might have questions about what's going on today and so forth. There's a lot to be covered. So let's actually have our panelists take a seat on the couch. Always nice. Therapy. Right. Then Jonathan as well. Yeah, if you like. I think we can, that's perfect. And then Jonathan maybe can sit down here. I'll take a seat here. We wanted to have a diverse kind of spread of disparate, but I would say interconnected slices of the blockchain space. So we have obviously academia represented in Jonathan. We have our expert legal practitioners from ORIC, very much an active firm in the space, as you probably know, and also sponsors of our festival. So thank you and welcome. And we also have Lisa Lefevre, who is at LGO Group, and she'll explain what that's all about. So self-introductions, Jonathan, if you'd like, unless you feel like.
I teach technology law, telecom law, startup law at Brooklyn Law School. And one interesting thing I've discovered over the past year or so is last year, all of my students were talking blockchain all the time. This year, I don't know, I have a couple theories on what happened, but no one really is talking blockchain this year. My students, everyone wanted to learn blockchain last year. No one cares about learning blockchain this year with a couple exceptions. I think what happened was the ICO meltdown and all the fraudulent transactions there, and everyone got a little bit panicky. But isn't that the perfect time for lawyers to get involved? If there aren't great opportunities now for lawyers in the blockchain space because of fraudulent ICOs, I don't know what is. I think we've all stepped back as an industry and we've got to rethink what's going on. Last year, the students and I built a prototype for a global blockchain policy wiki. The goal was to create something that the legal hackers community around the world could use to self-populate the laws of the respective countries and regions so that we could all share information across the globe and figure out where the havens and pariah states might be for different blockchain technologies. I would love to use this community again to relaunch that, something like that. A vehicle, essentially a crowdsourced, self-populatable vehicle for lawyers, mostly lawyers and policymakers, to understand the global framework. That's sort of what I want to throw out there. Things have changed a lot in recent past few months about what's going on around the world and among the states as far as blockchain rules and compliance and crypto compliance issues are concerned. And that's probably where this discussion is going to go to some extent, I think.
Does this work? Yeah. Hi, I'm Dan Nathan. I'm a member of the Gilded Legal Society. There's a separation here. I hope it's not. I hope it's not symbolic. Hopefully we're on the same. Hopefully we're on the same side of the issues. I hate to hear that where lawyers come in is to clean up the messes that are made. Being a member of a big firm, yeah, we make a lot of our, a lot of what we do comes down to economics and dollars and cents, and we're not quite vultures, but we make a lot of our money off of things that go wrong. And that's my career is, most of my career is with government, being one of the ones who makes things go wrong. I did enforcement work at the SEC, the CFTC, and FINRA, which regulates broker-dealers. So although I left 6 years ago, it was really before blockchain was a thing. So I went into private practice where I represent everybody who I used to go after in enforcement, and then have come into the blockchain world, which is a long prelude to saying, yeah, a lot of my work is cleaning things up, but hopefully more and more of my work is helping set things up in the right way. It takes a thief to catch a thief, and it also takes somebody who knows how to prosecute and bring cases to figure out how to make things work right. So I'm a member of our firm, and our firm is known for being highly innovative and being heavily into lots of types of new tech, also AI, also driverless vehicles. We won't talk about that today. And heavily into blockchain. And we are fully into every stage of the blockchain process so that I don't, by the way, I do lots of other work too, but I'm not sitting at my desk waiting for something to go wrong. If something goes wrong, we want to be involved. And, you know, being just 6 years in big law, I've managed to convince myself that everything I do is actually okay. It's all right. And 8 years ago, you wouldn't have heard me saying this. And let me just run down very quickly what big firms do, what big law and other law firms do in this area. And one of my former colleagues from another big law firm, Kavan Sadecki, who's with Schiff Hardin, can also fill in some. What we do in our firm in the blockchain area is basically 4 things. We help raise capital through for blockchain companies, through traditional means, through ICOs, through STOs, through SAFs. We help come to market. We help contract. It's called technology contracting. We help the product companies contract with others, basically. It's what lawyers traditionally do. It's called technology contracting, and we help put things in place, including contracts with all of your users, terms of service agreements, all of that. We do that. We also help entities who are under regulation by any regulator who are within jurisdiction come into compliance. And that's much more of what I do personally, because that's what draws in the background. So, and we'll get into, I assume, from Q's and A's, what areas there are, but there, you know, until we get into that modern world, the new world everybody's talking about, where, you know, you don't have to worry about a 60-year-old partner, hewing to traditional means, unfortunately, those are the systems we have to deal with. Those are the legal systems, that's there, and as much as we'd like to avoid it, and as much as cryptocurrency and the blockchain has been established to get around that, it's still there, and you can count on the regulators being 5 or 10 years behind technological innovation. So that's what we do. And then the last part is the vulture part. The last part of what we do is, again, when people get sued, investigated, sued by the government, prosecuted, we're there to try to help them out of it. And again, I feel good about it because in most cases, literally most cases, it's based on the government's misunderstanding of the area. And in most other cases, it's based on an entrepreneur's incomplete understanding of what's required. In very few cases is it based on somebody who wants to go out and rip people off. It just isn't. So again, I feel very good about being able to operate in that world. Let me introduce, and hopefully this should be Q&A, and hopefully I threw out enough there to whet your appetites and we may be calling on some of you to help pitch in, because we're going to stay within our lanes. You know, we know some stuff we don't know. So let me pass it on to my colleague, George Pesak.
All right, sir. Oh, perfect. Well, I'll take both. All right. Hi, my name is George Pesak. I'm also at ORC. I'm a managing associate there. Dan did a great job at introducing kind of what as a big law firm, how we view our ability to assist companies in the space, which is, I personally have a bit of a internal battle going, because I'm a believer in the space. I think it's going to bring about a lot of change. However, as a white-collar securities litigation attorney, the government's rules don't change as fast, right? So it's how do you continue to promote the development in the space within the construct that it has to fit within, and a lot of times it just doesn't. So a lot of these companies have to take the risk, go out there, make a huge enough change so that the government has to accept who they are, what they're doing, and change in that way. It usually doesn't happen, but when it does happen, it's a huge victory. We have seen a little bit of movement from the government's point. For example, Hinman's statement that you can have something that's issued as a security and then converts into a non-security. And then Clayton kind of jumped on and said and blessed that by saying that he agrees with that kind of analysis.
Very recent, right?
Very recently, right?
Yeah.
That's huge, right? The SEC does not move much on their rules. So the fact that they said that, there's some light at the end of the tunnel. However, that in itself raises a huge amount of legal questions, right? So, and we can get into those too, but it's not a complete victory. Now you have other regulators to worry about once you're no longer a security, so you have to think about that as well. So I think that's enough for me. So if you have, we're here to answer any questions that we can.
So first off, I just want to say thank you to Steve for organizing this and inviting me to be a part of this panel. I feel honored to be with this esteemed panel who probably knows a lot more, has been in this space longer than I have. But anyways, my name is Lisa Lefevre. I am a Compliance and Operations Associate at LGO Markets, which is a part of a larger company, LGO Group.
Okay, great.
Anyway, so a couple years ago, I was one of those students that Jonathan was describing. I had the honor of taking a class by Professor Shadab. Some of you guys might know him. I know he was involved in organizing this last year. So I had a class, he mentioned smart contracts and blockchain. I was like, oh, this is really interesting. I should probably write my final paper on this. And so I did that, and then that led to other papers, law review articles, etc. And I kind of saw when I was graduating from law school how it plays into securities law and securities litigation. And at the time, I was at a law firm who did securities litigation, so I was talking to the managing partner. I was like, this is something we need to be paying attention to. So at that point in my life, I was either going to continue at a law firm and maybe end up, if I was lucky, like one of you guys, but then I had the opportunity to meet the chief compliance officer at LGO Markets. And I was like, well, that'd be, really cool to take this other route and sort of go in-house and actually be a part of, what I view as like on the grounds, compliance and regulatory and legal work. So I guess we'll see. I mean, I learn a lot every day, and who knows, what could happen. I could stay there, go somewhere else. Anyways, what attracted me to the company was I see this, cryptocurrency exchange market. There's hacks every day. I think there's a new hack today. And they're, like the New York Attorney General's report, they're acting with all these conflicts of interest, manipulation, and LGO Markets, we aim to sort of do what is capable with this technology, that is, bring fairness, security, and transparency to a market where, it boasts about being like, oh, come join this decentralized financial ecosystem, when actually you're using a centralized exchange that might actually be, worse off as far as safety of your assets. But this company, I think, has taken, blockchain for one of its purest uses that I can see. We have an anti-front-running module built into our platform. We don't hold client assets. So it's also interesting from a regulatory perspective with our, sort of unique infrastructure. How does that fit into, traditional laws and, other centralized exchanges that are going the, money transmitter route, et cetera. So anyways, I welcome your questions, and I hope I can answer them.
Great, thank you for the introductions. Just to quickly reintroduce myself, Stephen Nam, Managing Editor of the Stanford Journal of Blockchain Law and Policy. We are basically the sole blockchain-focused academic journal at Stanford currently. And we're all about being a disinterested, neutral, hopefully reputable platform to advance discourse and really kind of have this layer of academic literature that others can build upon, whether that's practitioners, academia, and so forth. So happy to be here. We can begin the Q&A. I do have some very general starter questions that might help to kick off, unless someone wants to go first. These do not need to be answered in any particular order. Also, of course, the panelists can choose to kind of, bypass certain questions if it's sensitive. But let's always try to be respectful. My question, so these, again, don't need to be answered in any particular order. You can bowl over them as you like. For our Professor Askin, I was curious, so 2019 is obviously very different from 2017 and also 2018, right? The space is evolving very rapidly. We have seen a lot of, I would say, regulatory arbitrage across different jurisdictions, and even between, amongst the several federal agencies in the US that have more or less been tasked with oversight of the space. My question for you, Jonathan, is, do you feel like, as of now, today, the SEC, its general role, like most other federal agencies, of kind of having to balance protection of consumers with technological innovation and so forth, do you feel like you're comfortable with the pace or the approach that the US government has been taking? If yes, why? If not, why not? And that's for you. Quickly for Daniel and George. Also, just in terms of you being on the ground with a lot of these startups, these enterprises that are dealing with regulatory issues, compliance issues, what do you think, again, today, 2019, are some best practices that a lot of startup founders and staff might not really be cognizant of? Because as you know, a lot of these startups don't have upfront legal help or in-house counsel that you might want to kind of warn them of, caveats, et cetera, steer them towards, et cetera. And Lisa, for you, you're very much in the space with a company that's active, again, in the spirit of decentralization. What are some, I believe, am I correct, there was an ICO, is that LGO? There was an ICO recently,
LGO
right?
Group, yeah, they did
Yes.
an ICO under their French entity.
Okay, oh, okay, interesting, okay, got it. That was very recent, right, February or so? Never mind, okay, so just curious, like what I guess regulatory compliance issues you are facing in general on a weekly basis, and perhaps what you foresee. So again, doesn't have to be particular order.
Well, I'll start. I think we are beset with regulatory uncertainty beyond anything we've ever seen in the history of humanity, and that is devastating for business certitude and consumer certitude. So here are the big problems. We have way too many entities, authorities that are regulating different aspects in different ways. You've got local governments, state governments, federal governments, international, foreign governments, international treaties, and no one knows what the rules of the road are. I'm an old telecom lawyer, and the one thing I learned in 20 years of telecom is that you can never be sure what the next administration or the next jurisdiction is going to do to your venture, so you've got to prepare for all contingencies. That's a terrible way to run a business. For those of you who followed any of the net neutrality telecom battles, one year you got net neutrality rules and you know what the rules of the road are, and the next year you don't. And it depends on where you are in the world. That's why we started last year this effort to create a global policy wiki, so we can get some understanding of what the map looks like globally. So the things I like now are the regulatory laboratories. How many of you are following what's going on in Wyoming, for instance? Wyoming is trying to become a haven for crypto and blockchain ventures. Are they going to succeed in a world in at least a country with federal supremacy? I don't know. But they're trying to, Vermont now has at least a rudimentary, we heard about this last night, a rudimentary statute allowing for LLC formation on the blockchain. It's a baby step into something. Delaware's trying. If you think about what's going on in Wyoming, this is not the first time Wyoming has tried to disrupt the business world with a new technology or a new product. I think it was 30 years ago, 40 years ago now, Wyoming was the first state, I think, to pass an LLC statute. It was an effort to turn Wyoming into the Delaware of flexible corporations, essentially. Delaware owned the C Corp. Could Wyoming create this new sort of corporation that would be more flexible than a traditional C Corp? Well, Wyoming succeeded, and it succeeded like gangbusters, so much so that every other state adopted the tool. So I think this is what we're going to see in the crypto space. We're going to see these state or foreign state laboratories, and people are going to flock to them. We'll see a lot of successes and failures. I think to some extent the federal government might be right to hang back a little bit and see what Estonia is going to succeed or not succeed, and what Wyoming might succeed or not succeed at an interstate level. But I have no great hopes that our federal government, especially if it fluctuates between administrations, Republican guards, Democratic guards, CFTC versus SEC versus Treasury, what have you, I don't think we're going to see much certitude from the feds in this process. So we've got to be out there looking for other havens in our own laboratories where we can actually prove out the concepts.
Yeah, it's sort of the only area where Wyoming and Estonia are used in the same sentence. Right? Otherwise, they, I think, have almost nothing in common. Although I don't know what the terrain is like in Estonia. Is it mountainous, and do they ride the range? So yeah, the comment about laboratories is great. It's fascinating. Look, 10 years from now, we'll look back and see the kind of gradual focusing and unblurring of this whole area. Right now, it's, on both the government and the entrepreneurial side, things are blurred and developing in different fits and starts. I guess the one thing to add to Jonathan's answer about the differences between 2017 and 19. I think 2017, in the very heady days of saying, hey, let's use the blockchain for everything, you had people raising money for blockchain applications using, ICOs in the blockchain. We're seeing a lot less of that now. We're seeing, yes, you have a practical application and you need funding. Let's go back to what's being done traditionally. We know how to do it. We've done it. Why make it more complicated with having these sort of hybrid tokens that George referred to, where it starts out as something that's security and then becomes not a security? At what point does it stop being one? Can you draw a line there? At what point are you subject to SEC versus CFTC jurisdiction? At what point are you vulnerable to certain cause of action versus others? And we can get more into that. But that's again just to supplement these comments. We're still in year one of a 10 or 20 year progression. As far as I guess practical first step things to keep in mind, best practices. I'm tempted to say, because my law firm sponsors for me to be here, get a lawyer. But I rarely like to say that. I mean, the real first step is figure out what you have and how it fits into the regulatory scheme, and whether you need a lawyer for that or somebody in house to figure that out is a question up to you. But you do need to know from early on how it fits into the schemes, and you can't do it stepwise. Right off the bat, you need to figure out what you have, and you need to figure out if you need to have in place compliance programs to deal with a whole multitude of different laws. And it's better to do it right up front. The SEC and the other regulators have been slow in getting started on non-fraud matters, and we can talk about how these agencies typically progress in a new area and how they develop their enforcement scheme. But it's going to happen. They're going to get into the non-fraud sort of regulatory areas, and you don't want to be caught short there. So if you figure out right off the bat what you're dealing with is something involving, say, transmission of money, which is something very, very broadly defined, and gets you in the jurisdiction of the anti-money laundering regulators, they're very specific, detailed, and highly enforced requirements you need to have there. So the first best practice is figure out what you got and make sure you have your systems set up around that. What else would you add, George?
Well, so I agree with everything everybody has said so far. I think with regard to am I comfortable or do I appreciate the pace with which the federal government is moving in the regulatory approach to the blockchain space? I'm surprised I'm going to say this in public, but I actually am, right? And the reason that I am is because 2 years ago, tokens were being used for one thing. Now that same token is being used for 10 different things, right? So it's like if we can't have the federal regulatory system changing every single time a new product comes into market. So it has to be stable so that companies can build systems around it. And when there is a change, that change really needs to be thought out, because it's not just affecting the new participants in the market, but the legacy participants, right? So it should be slow. And I think that's one of the things that makes our system so desirable, right? Because people, even though they'll complain about all the regulation, I think there's a lot of benefit there to the stability. The other thing too, what I would advise new companies in the space trying to save money on legal costs is, like Dan said, figure out what exactly you have and be able to articulate that in a very concise and clear way, and make sure that you're not venturing off into multiple areas, right? You really do need an attorney here, because to the extent that you're going to avail yourself to the U.S. capital markets, right? There's some rules that you got to play by. You can't just do it. There are rules that have to be enforced, and so just understand that that's just the system. Similarly, if you understand what the token you're offering is or what it is that you're trying to do, it's easier for an attorney to be able to advise you, and it'd be cheaper, right? If you come to an attorney and tell them, like, look, this is my idea, and 2 years from now, my token, so it'll be a currency now, but 2 years from now, we're actually gonna make it so that you can do X with it. Well, now I've got to analyze your legal requirements around your first proposal. Then when it changes, what does that become then? And then what happens to the initial requirements that we put in place? Everything molds. So really, you should understand what you have so that we can help you as efficiently as possible and keep the bills low.
So sort of going off that, we definitely have outside counsel, but I see there being real value in having lawyers in-house to sort of see these challenges as they come up on a daily basis, because there are a lot of challenges that come up, and it's very expensive to get on the phone with your lawyer, which we do that often, but are you going to have your outside counsel there every single move that your company is making, especially in this space where things are moving so fast? I remember on my first day, someone was like, oh, what is it, like a week here is like 6 months somewhere else. And I was like, now being there for 6 months, I was like, that's really true. And there's no way I can really briefly describe the type of issues that we're experiencing and working through. But one thing I wanted to note, going off what you said, it made me think about something Hester Peirce said, it was like a week ago or something, that this sort of ambiguity in the space, the fact that the SEC hasn't, provided the sort of guidance that people might want, gives innovation room to sort of grow and, I guess, press those boundaries. I don't know, I sort of take a middle ground. I think regulators could do more to sort of provide that clarity without, I guess, shoeboxing the industry in, which obviously leads me to thinking about BitLicense, which I think, at one point it was, I'm sure there's some opinions about that in here, and someone asked some questions about it, but from one point of view, it was regulators acting quickly to sort of try to provide safety for New York residents. But on another note, looking at BitLicense now, a couple years later, is like they weren't fully apprised of the technology and the how complex it really is. Let's just throw BitLicense out there and see what happens. Because now in our business, we're like, okay, we have to deal with this. We're applying for BitLicense, etc. But some other companies, like, what if BitLicense doesn't apply? There's no definition of control in BitLicense. And that's just something that I've been thinking about lately, especially with like the model acts. Like, I've looked at those, and they do have a definition of control, which I think is more, as it applies to us, it's, what the definition would be, unilateral ability to move funds or prevent funds. And from our business model, I look at that and we use 203 multi-sig. So our clearing firm has a key, we have a key, and our client has a key. So my view on that is that we can't unilaterally move our clients' funds, and I think that's where like our security comes in place. And we don't want to be able to unilaterally move client funds. So just thinking about that, that's something I'm thinking about on a daily, weekly basis. Also, I mean, money transmitter laws. Where does that apply, and where does that not apply? We don't hold customer funds, so does some states. We still might apply. So that's just some of the things I'm thinking about. I mean, there's cases every week, it seems like. There's also like civil litigation going on. So like, how does that play into us? And these regulators coming out with these statements, and then I think it was like a week ago, Jay Clayton wrote a letter in response to a senator. We all thought this was going to be some of that plain English guidance that they've been promising, but really it's just more of dancing around the issue, basically. So, I mean, that's just like a little bit of the things I'm thinking about, and I'm pretty sure other people in similar positions in the industry are also thinking about, as far as, in-house compliance. What can I do to be proactive about what might apply to us, what's happening in the industry, how are these changes going to impact the business directly, and how can I, get ahead of that so that we're best positioned to handle it. And, working with outside counsel also is just, very necessary, like you guys said.
Great, thank you. Now let's open it up to the floor. I always have more questions, but I'd like to hear more from the audience, so let's make it interactive. Anything at all, if just what? Yeah, go ahead.
Great. Brief one to follow up on not holding the funds in unilateral. That's awesome. Seems very kind of eating your own dog food, if you will. Like, I was curious from your perspectives. I mean, especially you two, what you're willing to say around the tech contracting terms of service. just played around on your cookies and website. I'm curious, where are you following through on this? Like in your corporations, academia might be a little more difficult, but yeah, that's.
Anyone have the other wireless mic?
Are we sitting on it?
We'll look around.
Yeah.
Oh, here it is.
Oh, perfect. All right. Great. Thanks. Yep.
Big comfy couch.
Yeah, I'm not fully sure I understand the question about terms of service. What?
No, just in general, like, what are you doing to, I mean, everybody's caveating you're here for the same philosophy, break the mold, keep pushing this forward, you're helping your clients. So what are you doing internally or for yourselves or, you know, as I said, like the term eating your own dog food, you know, like maybe it's a class for you that you're teaching, et cetera. Is there anything that Work's doing, you know, that you like to promote or anything like that internally?
Well, I identified the 4 areas that law firms generally get involved in. We're involved in all of them. We're with hopefully some fairly innovative companies involved with them, and cradle to grave service. We don't not unnecessary service, things we can live with, but things that that they all need, and we're holding their hands and getting them into the process, including. Look, we have a robust capital markets group, and we like to help introduce people to people who we think are good funders and good incubators in this area, and help them raise funds through them, and then help them make sure that their products are in gear. Again, I'm being relatively new to private practice. I'm reluctant to have somebody pay a penny more than they need to for what they need. So I want to identify what they need, what services they have, and figure out, as Stephen says, best practices up front.
So for better or worse, I have spent the past 12 years destroying the livelihoods of my students and the profession. I'll give you a couple stories. And it's been, you say eating your own dog food. Eating this dog food has been a very hard pill for me to swallow. About 9 years ago, I think, so my students and I give free legal support for innovative startup ventures. 9 years ago was the first time I saw the rumblings of what was going to happen to the legal profession. There was a company, 2 MIT engineers were launching a product called Docracy. Who's heard of Docracy? No one, okay. Docracy got bought about 3 weeks ago. Docracy is right now, I think, the largest open source, crowdsourced repository of legal documents in the world. It's built on GitHub. It allows mostly young lawyers to populate the site with contracts and take other people's contracts and annotate them and share them. It's just a very, very deep repository. And so these 2 non-lawyer engineers came to me and my students and said, can you help us build this site? And I said, let me get this straight. You want us to help you build a site that is going to destroy the chances of my students getting jobs as first-year associates at the New York firms where they will be writing contracts. And they said yes. And I said, get the hell out of school. We don't want anything to do. And then I stopped for a second. I thought, this is inevitable. And wouldn't it be better for me and my law students at Brooklyn Law School to be on the cutting edge and to be aware of what was going on? Keep your enemies close is sort of the negative way to put it. So we went into Docracy with full gusto. We populated that site more than any other lawyers in the world. And then I realized that, look, there's no doubt the legal profession is going to change, and it's going to change dramatically. And can we figure out what the tasks will be for the lawyers? No, Ray, you got something to say? What the tasks for the lawyers will be, what the tasks for the AI will be, and to make sure that our graduates are the ones that understand how they partner with automation and AI and serve the function that only the lawyers can do. And frankly, I'm convinced that the last profession that will be destroyed by automation and AI is the legal profession. And that's because we are trained to do exactly, or we're supposed to be trained in law school to do exactly what the AI will never do. The AI loves ones and zeros. The lawyer is supposed to work in the gray area, to work with ambiguity and nuance. Medical profession will be disrupted way earlier than the legal profession because we work in the gray area. So everything. So now we're holding all these automation workshops now. We're working with Community Lawyer, with Neurologic, with the other tools that will essentially get rid of the test. When I graduated from law school, I went to big law, and I had not an enjoyable couple of years. And I would like to think that if I was coming out of law school now, big law would not be a bad place for me to go now, because I would actually be using my training appropriately. I'd be learning to think and participate like a real lawyer and not taking templates and sending the templated documents out to clients. So I think it's ultimately good. Legal hackers started because of the economic downturn in the legal profession. My students could not get jobs coming out of law school, so they had to rethink how they were going to maintain a career with a law degree for the next 60 years in a world where the law firm wasn't going to embrace them for the entirety of their career. And so legal hackers emerged. We decided we're going to figure out how to think like the startups around us and help to build a profession that has that hacker startup ethos.
Here's what kills me. I'll give you a little insight into law economics. When you're doing a corporate contract, non-litigation assignment, the clients watch every penny like a hawk. And it's 12 minutes of work, you know, why did you spend the 13th minute? What did you do there? Why did I pay for a cup of coffee here? Everything. When it turns into litigation, enforcement, suddenly all bets are off. Suddenly it's hours, days, weeks of time put into defense work. I'm not saying it's unnecessary work, but suddenly it's bet the company, it's bet the house. A lot of it's insured, so that's okay too. But the transition from one to the other is remarkable, which is why the upfront work, it should be almost flipped. The upfront work, which is really protective, it's putting your systems in place to make sure your compliance is adequate, should be what's well paid and should be what's spent on. And the litigation stuff, a lot of it is just, you know, fighting and yelling at the phone and, you know, why did you ask that question? And why do you know, there's a lot of crap, but it's time consuming, and unfortunately it's a creature of legal work.
Yeah, so like the economics sounds like you're engineering it to prevent legal disasters. Where did you learn about economics?
Gee, I wouldn't. It was a few years ago.
What I'll add to that is what I think I'm doing internally myself to try to promote the space. Given that I'm not at the partner level and I can't really make that much movement, I think one of the things that's important, and I think I do it well, and Dan could attest to this, is I will talk to anybody at the firm about blockchain whenever they want to talk about it. And the beauty about blockchain is that it has so many different uses that I find myself having discussions with people from the energy group, people from capital markets, people, all these different groups, because it does apply. And the first thing that you have to get an older generation to accept is the legitimacy of the technology, because at first, and especially during the frothy season of these ICOs and all the publicity that was out there, and the reasonable position that older partners was taking is this is just a fad. We've seen this before. This is going to die down. And the thing is, maybe the ICOs were fads, but the underlying technology is here to stay. And we need to understand that, and so I have these conversations all the time, and I'm happy to say that I think I've made a little bit of headway with it. So
I think the only thing that I want to add to that is, I mean, I haven't been in the space as long as some of the panelists up here, but even in my short time in the space, I've seen lawyers who have either stopped practicing to do something else, or been practicing but sort of just going with the status quo and not really excited about their practice anymore. But I've had lawyers who I've known who are like more excited about the law than ever, and lawyers who have gone to do something else, they're like, because of blockchain and all these, legal issues, how interesting and emerging it is, they've gone back to practicing law. So I just think that's something cool where, we have people talking about automated, taking away legal jobs, et cetera, but there are a group that are, have a renewed, I guess, just interest in their profession again. So I think that's just something really cool to see, and I'm sure I'll see more of it.
Well, fun. Let's go to Wyoming.
Hey. Hi, Kayvon Sadeghi at Schiff Hardin. Thanks for the shout out a little while ago, Dan, former colleague. I guess I have a question that's sort of related to the last question, so maybe I'll start off by adding something you could mention there, which a lot of our firms are cooperating with each other and things like the Wall Street Blockchain Alliance. I think our meeting on Monday is actually at ORIC in New York, and that's a place where a lot of the lawyers are getting together and sharing knowledge in this space, which is not always the case otherwise, but we're all, sort of the view that if there's a rising tide and there's a need to cooperate and work together, which is nice to see in this space. A lot of us are advising companies on the side as well, doing things like that. I guess my question is, The SEC, the CFTC, I think, are taking a very pragmatic approach, as you talked about. They're sort of developing the law, go after low-hanging fruit, set the ground rules. If these are securities, then they can start moving up to the bigger projects that are going to be well defended. Once they already have a body of law, they're taking a very systematic approach to developing the law they want to see developed. What can the industry do on the other side of that? The industry's response seems to be very haphazard. We see Kik wants to fight back, or Kraken, says they want to fight back against the New York AG, but it doesn't seem like there's a systematic industry-wide approach to developing the law on the other side. We're essentially letting the SEC roll over the industry, pick the low-hanging fruit projects, get law made based on cases that aren't being well defended, and build the law the way they want to. What can the industry do on the other side to systematically build the law the way the industry thinks is appropriate?
Yeah, that's a great question. I'd take a crack at it, but if anybody's more eager to than I. Yeah, well, look, what Kik is doing is right, resisting. What other companies are doing to resist is just human behavior. I mean, Blockfest, caused the SEC to suffer a rare loss at the TRO's preliminary injunction stage, even though Blockfest, nobody hears with Blockfest, right? I mean, Blockfest had terrible patent fraud, clear fraud. I mean, invented a whole regulator that they posted on their website, terrible stuff, and yet they beat the SEC there. But, we're not here to defend the people who make misrepresentations and rip people off. We're not here about that. The traditional actors, I think, should pay attention and work with the regulators about what they're doing. They are applying the law correctly, the regulators, as far as I can tell, and they are doing it. I echo what George said. They are doing it in a systematic way. They got caught short early on. They clearly were left behind by Bitcoin and Ethereum. And they had to back and fill and catch up, and conveniently, those tokens had, at that point, clearly were things you could define as not securities. And I think maybe it's just because we've all been pulled into the analysis now, we can all accept the fact that they're not securities, and so the lines were drawn there. But the interpretations of the Investment Company Act, of what makes something a security, of what makes somebody a broker-dealer if the underlying product they're dealing with is a security, what makes something an exchange, and exchange is obviously where a lot of the action is. The SEC's applications of its laws seem defensible. And what I'd say is that the structures that are being created to work within those laws are structures that should be adopted uniformly, the way in which the structures were adopted in the more traditional securities world. I think that's the way to work with them, while to the extent you have a better mousetrap, to the extent you can build something new, you sit down and you talk to them. The SEC is meeting with, supposedly they're taking 3 meetings a week in their regulatory divisions to talk about new structures, to talk about approving what's going on. Take them at their word, meet with them, run something by them, try to demand an answer. They won't give you any clear answer, but I think they'll make an ugly face if they don't like what they're seeing. And I think that's the way to in sort of a Zen-like way, work with them.
Can I add one thing? So in Legal Hackers, we're very interested in the ethic of leading and then making available, workable tools for different areas of law, including regulators. One thing that comes to mind is Nina Kilbride, who's a legal hacker in the Research Triangle area, was working with us on a hackathon for people that were doing ICOs, and part of the design of that was a team that had an interesting idea where they wanted to take a path where it would not be covered by basically securities law, included a no action letter. So what would be your request for a no action letter? And that was tuned to the state securities officials. It just as easily could have been tuned to SEC. That's something to keep in mind. The other thing is, if you look at another dimension, which is commodities in the CFTC, they now have CFTC labs where they're really embracing collaborations with people to come up with new types of instruments that comply or that clearly are out of scope. So I think there are some touch points, and I like your attitude very much about how can people in the industry actually be proactive about this. So I think the answer is just do it, keep doing it. I'm actually holding the mic and I'm not supposed to be talking, so after Jonathan says something, anyone that has a question, raise your hand and I'll bring the mic to you.
So
Who's read the Foundation trilogy? I think we are living in sort of the era of the Foundation trilogy where the future is almost inevitable and already written for us, and it's not good. Here's the world. If we could have planned the rollout of blockchain and crypto, we would not have done the first proof of concept be technology that disrupts financial markets. That's global financial markets. That would be the worst first proof of concept. We would have taken very rudimentary baby steps to prove the concept in very isolated circumstances and shown governments that this is viable, technology can work, and take baby steps into the major disruption of major global sectors like finance and media and governance. But that's not the world that we're stuck with, the world we got. And the problem is we're stuck in a world where bad facts make bad laws. We are not instituting the policy reform or the statutory reform or the judicial reform. Daza hit on the perfect concept. In a better world, if we could be working with government, hacking within government to show them how it can be done, and getting these sorts of no action letters or attorney general comfort letters, what have you, that is a beautiful place to be. But what we're doing is we have rewarded the worst actors in blockchain and crypto. You have to be the craziest person in order to get in the spotlight and to get your idea, which means you have to violate anyone who's abiding by the law is not going to be first to market. First to market is the one who doesn't give a damn about the law and just goes ahead with gusto. And those are the ones that are going to get the spotlight and government's going to watch, and those bad facts are going to create the bad law. We're also living in a world where everyone and his brother wants to run the policy framework for the blockchain crypto world. So what do we see? These rivalries between all these would-be trade associations, all these policy advocacy shops that pretend that they are the voice of the industry. And you've got to be loud and vocal and promote the interests of the most radicalized blockchain crypto companies in order to be the voice of the industry. And you're not necessarily doing a good job bridging the needs of the industry with the commands and of government and the broadest public policy. So if we could create sort of these new trade associations, these policy advocacy shops, blockchain for good, that's the great way to do it, I think. What? Yeah, so this is the community. Look, I always thought, I want to launch everything, and this is why I thought the global legal hackers movement is sort of perfect. It's got 140 chapters around the world, all young lawyers committed to using technology to advance the law, legal process, and the public good. That's an army. That's a global army of do-gooders that want to do this. Now, and I'm not saying it's the only one, but who's going to fund us, though, is the problem. How do you create this army when you've got all the big money supporting the most radicalized blockchain crypto ventures? And we're going to see all these fits and starts in the government. They might rule one way today. They're going to rule another way next year when the administration changes or someone else gets a new bee in their bonnet over the issues. So we cannot count on government in a vacuum to do anything good for us on this.
Yep, sorry. I'll make it really quick. The only thing I'll add to that is that the industry participants should focus on surviving. Survive and stabilize and create products that people use, and at that point, I think that would give me enough time to talk to every single partner at my law firm and explain to them what blockchain is, and then I could point to successful products that are using the technology and aren't necessarily bad actors, and I use that as an anecdote, but it's just because the industry has to mature to be accepted, and for regulators to decide, okay, we need to change our rules, and because that's what's going to need to happen. Rules will need to change. So.
Yeah, actually, I love Jonathan's answer. It's terrific. What George is saying. I guess what I'm saying is, you need to survive. Don't pick unnecessary fights. I mean, there's a lot of philosophy behind the blockchain, which is that we're apart from the traditional banking world, et cetera. So traditional rules don't apply to us, and that may be true in the abstract. But the government has shown its willingness to crack down, and why sacrifice yourself at the altar of your philosophy? So that's what I'd say. Find and work with lawyers or whoever else to figure out a way to compromise and bridge the gaps. But don't thumb your nose at the government, because they do have a lot of resources, and you catch them on a bad day, and they'll screw you, and it's just not worth it.
Hi, panel. Yes. I'm Monko from justcoin.com. Thank you, panel, for very insightful information. With the boom of blockchain, we put more and more information on the blockchain. And what do you think about GDPR, which is General Data Protection Regulations? Do you think this will promote use of the blockchain? And do you think blockchain is compliant with the GDPR, or is it on the same side, opposite side? What do you think?
Fantastic question, and it's a question no one really thought about until about 1.5 years ago. We were all thinking immediately, oh my God, is blockchain the great panacea for GDPR compliance? It's inevitable. The EU will say, you must put everything on the blockchain. That's the way you encrypt and secure all information. And then we scratched it a little bit. Oh, I see one of the folks here who wrote a letter to the EU right in advance of the May 25th launch of the GDPR. The issue they dealt with, some of my students dealt with, was they were concerned about the logical conclusion that the blockchain technology will never be GDPR compliant because of the right to be forgotten. It's forever immutable. And should that be a reason to outlaw blockchain technology in Europe, or does Europe miss the mark? Is there an overall broader principle that says blockchain technology is probably a great way to advance and enhance privacy in Europe, but for the fact that you may not be able to comply with the right to be forgotten? So shouldn't there be some carve-out, some exception to recognize the overall advantages of blockchain in a privacy-sanctifying world, and then figure out whether or not there are workarounds on the right to be forgotten issue there? So that was sort of the third rail issue for us. Is it dead in the water because it can't satisfy the right to be forgotten?
So I mean, just a quick answer to that. My first assignment at LGO was actually I created GDPR policy, and so I had to basically learn about what this is and how it could impact this business that I just joined, and then really just trying to learn about. But anyways, that's something that complying with AML and KYC obligations, we have to sort of ask our vendors, okay, so we're giving you this information, like our client's passport, ID, etc. How are we going to be sure that once we release that to you, that that you're erasing it within 14 days like you're telling us we are? So that's been something that we've thought about. And then from the blockchain aspect, I'm probably not best at describing it, but how we do it, we have a centralized order book where it's centralized for efficiency reasons, and then on-chain, after orders are matched, we have the transactions batched and put on the Bitcoin blockchain. So that has no PII, so we think that's compliant and that there's no customer information that's saved in this immutable, sort of way. So,
I do know our journal received a submission recently that addresses the French government's kind of response to this situation, right, where there might be not so much coherence between blockchain and GDPR, and I'm happy to say that there is some kind of some sandboxing. Depends on the jurisdiction, but there are efforts to kind of address this issue because enough people realize that there is some incompatibility. So it's not like people are sticking their heads in the sand. It is being worked on. Coming from an antitrust background, I was a lawyer for about 4 or 5 years at James Day. One thing's for sure, it behooves a lot of national governments to really work on these issues because, again, no one wants to be left behind. So I think there are enough kind of voices of reason hopefully embedded in different agencies of different national governments to understand that it's something they need to work on with hopefully some polycentric cooperation. By that I mean, not just consulting government people, but also civil society, startups, practitioners, so forth. I think it's pretty much become more of an accepted model rather than just calling the shots from above. So hopefully we see more of that.
Thank you so much for your time. I'm Christopher. I'm a student at the Brooklyn Law School. I'm a practitioner from Trinidad and Tobago. And it's recently been announced that the Eastern Caribbean Central Bank is launching a blockchain-based currency. And so I'm seeing an international recognition of the power of the platform going forward. And what's really interesting to me is that technocrats are taking it to the point where they're willing to make themselves petri dishes. And I was wondering whether you think that it is possible within the states that maybe a state would take on the position of being that petri dish to see different ways in which administrative procedures could be used to implement and enhance American uses of the blockchain technology.
So, perfect question. The problem is the supremacy clause of the U.S. Constitution and the nature of internet communications because they traverse interstate boundaries. Wyoming is trying. I asked earlier who was aware of what's going on. Wyoming is trying to create an interstate petri dish. And at last year's Computational Law and Blockchain Festival, a bunch of the students and participants tried to create a mechanism by which they could allow for Wyoming to become that petri dish. At least that was one of the approaches. The thought was, can you create a, so Wyoming has essentially said it's a haven for crypto transactions, period. The problem is, if they can keep it in the state, it could be fine. It might not invoke any supremacy clause issues, any federalism issues. But the problem is, how do you allow everyone else who wants to participate in the market to be actual participants within Wyoming itself? So the thinking we had was, can we create, anyone who wants to participate, set up an LLC within Wyoming? So you could be a New York resident, but you run an LLC in Wyoming. And when you buy the crypto within Wyoming or participate in the blockchain activity within Wyoming, it's strictly within the state of Wyoming. If that became viable, the problem was the economics didn't quite work out.
Well, I mean, just as a matter of rejoinder, I think taking an example or idea to a further extent, it could be possible that Wyoming could pass legislation to not only to make a derivation of a legal personality that strictly for this purpose, where participants can register under this personality and therefore become Wyoming residents for this purpose, for a non-economic purpose, and they'll only pay taxes on their, let's call it blockchain transactions or whatever.
So I love it. So yeah, Wyoming, I think it costs $99 to become an LLC in Wyoming, and I think you could become a series LLC in Wyoming, which means, and Brendan might know more about this. You could become so that every time you wanted to participate, you create this new LLC, but it's still that $99 threshold. Could you create this micro entity for $1, say? That would be an interesting approach for Wyoming. And I don't know, has anyone been exploring what's been going on in Wyoming or the other states in this regard? Yeah. Okay. Anything more? Did I miss a nuance that Wyoming has been exploring more recently? And if folks know about other states, that's great.
Great, thanks. I think fundamentally the important thing to think about in this space is goes back to use, right? What are these things used for? Are they securities? Are they not securities? Are they property? If it's property, states have jurisdiction, right? What if it's something fundamentally different? Like the missing part of the machine. I mean, fundamentally, blockchains are about identity, right? So that doesn't fall under the jurisdiction of any of these financial institutions. And the fact of the matter is that you can take anything and you can run a process on that. You can make it a hash of that and put that on a blockchain. So what is it now? We have to think about these things as their use and their representation.
Actually, can I make a comment? On GDPR, GDPR is not just right to be forgotten. If you look down to Article 15, people have a right to get a copy of their personal data. How about an Oracle or an integration that makes it simple to get all of your transactions or all the references if it's more like a data file? Another great one is the algorithmic decision-making section. So with DAOs and smart contracts, they would qualify as algorithmic, and if there's some sort of decision that affects your legal rights, like, is my loan approved or not, there's a requirement under GDPR that the people operating the system be able to explain the algorithm and how it achieved those results. I think there's a lot in the GDPR that's very, very friendly to and suggests a good direction of innovation for people who are interested in blockchain and other innovative technologies for the law. Do we have time for one more question, Steve, before we...
I think one more, then
okay.
Break for lunch.
Sir.
So if any of you have a dream no action letter that you think you could reasonably get the SEC to grant no action relief on, what would it be?
Wow. I'd like to get the SEC to give more guidance through a no action relief as to when an entity or a blockchain has become sufficiently decentralized so that it's no longer a security. I think that would help a lot of companies that issued their tokens or entered into a SAFT, right? And now they're waiting to issue the tokens to their SAFT participants. And if they want to use that argument, it'd be great to get the SEC's kind of detailed analysis on at least another use case other than Ethereum where they've seen that happen.
Yeah, I agree. That's something that, I'd be interested in having them, talk more about. There's a podcast I was listening to the other day where they were talking about how, the SEC is sort of like so far set up decentralization as a standard for, thinking about securities laws. And, it's decentralization is sort of vague. How many nodes, how many holders do you need? So that's something the SEC I would like to hear more about. Also, I guess then my answer would be, something about custody or control. Like I'd ask them, is this in our situation at LGO markets where we have multi-sig, we have control spread across parties? I mean, I guess, I don't know. How does that fall,
Yeah, I was going to echo the latter. There's so many sort of regulated type entities under the securities and commodities laws, and that if an entity is not involved in real custody, can you have a lighter regime of regulation that doesn't incorporate the full 34 Act requirements?
Yeah, like some sort of risk base. Okay, you're only holding one key to the asset. How can regulations sort of view that through like a risk-based lens? Exactly.
That's a great question. Yeah.
So I wouldn't trust I wouldn't trust a no action letter from the SEC as, it's not worth the paper it's printed on because it will have, at least on substance. As a substantive matter, it won't last beyond the administration or the next review. What I would trust the SEC maybe is to do something on limited process reform. So could they create some sort of rocket docket, an expedited procedure where you can actually make a request of the SEC. It may last for a short duration, but at least you can ask them a specific question and they'll come up with a quick answer. So they've done, the federal government's done that in other contexts, rocket dockets for patent relief kind of issues. Could they do a rocket docket for a crypto blockchain question process? That might make sense.
Okay, thank you. Thanks to have a round of applause for our awesome panelists. For the audience as well, awesome questions. Break for lunch. Feel free to ask more questions amongst yourselves. Network as you please. And
okay, thanks. And actually, so we do have lunch coming. There's lots of pizza, because pizza is hackers' main source of nourishment. But I'm not sure. Is Emmerich here? I think he's actually getting it right now. But something I'd like to do before we start. Could you help me? Could you put one of these on here? Post it. So we've got arguable. So although the pizza is also coming to us. So what I'd like to do before we kind of mix and mingle, we built a fairly generous lunch hour and a half into the schedule for people to meet. But to help catalyze meeting people, I want to just go over what the breakout sessions are so far, and then see if anyone else wanted to add a breakout session so that you could know what they're going to be. So the first one, actually, could I enlist you? Do you mind reading these? What's the first one? It says here. Governing data. So the first one is data as property. And who's that? Williams? Okay. So I'm just going to shorthand it as data as property for this. So data as property. And what's the name?
It's Mr. Perry.
P-E-R-R-Y? P-E-R-R-Y. And could you raise your hand? So here is Mr. Perry, who's got a lot to say about how to recombobulate the bundle of rights that is property for the digital age. And you'll be facilitating that session. So this will be one of the breakouts. What's the next one? So contracts for dApps. Is Kurt here? Just raise your hand so everyone can see. And Kurt's going to go over a contract he did for a dApp marketplace. So you know how there's like a terms and conditions when you go to the Google Play Store or Apple, App Store. What would that look like for a distributed application marketplace? So he's actually done one as part of his practice of law, and he'll do a run through of that, and we can share some of that knowledge. What's the next one?
Design and development.
Kurt. Oh, that's a big one. Hey, Beth. Oh, Beth.
That's upstairs.
DAO design. Here she comes. Beth. But let's move to the next one, and then Beth will. What's the next one?
Smart contracts and open law.
Okay, open law. Anne, are you here? Actually, why don't you come on up? Anne, and Mr. Perry, why don't you come up too? Are there any others that are on there? Okay, so we have room to add more. So let's start with really what? Walter Perry, right? I forgot. I'm sorry. Okay, so okay, everyone. So what we're going to do is, I'm going to give everybody that's doing a breakout session the mic for a minute so you can get a sense of what they'll talk about. And then you can self-select the session you want. So let's give some space here. And that'll be a lunch talk, a little different. It'll be down here. Okay, so Walter, what's your breakout about?
We're working on the assumption that data has some substantive reality as property. And if that's so, it should be governed to some extent by the traditional bundle of rights, which are seen to govern property. The right to alienate, the right to hypothecate, the right to license, the right to exclude. And if those two things are so, where is the substance where that property resides? What is the locus of that value?
Awesome. And Kurt, come on up. What is your, I kind of already sort of said what your session was about a little bit, I guess, but let's get it from the authoritative source.
Sure. Thank you. So one of the main things about law as it encounters blockchain is the fact that law traditionally thinks of centralized parties. There's a door you can knock on if something goes wrong. And the nature of blockchain is such that, that's antithetical to its purpose. So how do you deal with, putting things out there that, could go wrong, that could cause people losses, and what are going to be those recourses for those people, and how are you going to govern, the indemnities for like who's covering the loss, and how do you limit liability, once you put it out there. Just as a very brief real world example, Ether Delta, when it got popped, they came after the guy who put out the tools because he was the one who facilitated everything. But going forward, is that the responsible thing to do, that someone who makes something and puts it out into the world, and then 2 years later it causes a problem, should you continue to hold that person accountable? So the contract we'll be reviewing is like, how do you handle those with a dApp?
And there's so many parties to choose from, the marketplace provider, the original creators of the app, the people that are operating the app, the people that hacked it maybe in the bad way.
Yep.
Okay, so Beth, are you down here? Beth. Okay, let's move on to open law.
Hi everyone, again, Open Law. I'm Anne, I'm the product manager, and this is Michael. He's one of our legal engineers. So our session, obviously, so Open Law, we're the legal protocol that sits on top of the blockchain. Our goal is to make it a lot easier for legal professionals and other people to actually interact with the blockchain, and so people can actually just focus on the product or their day job. So we have a number of products, anything from kind of signing that is saved to the blockchain to automating legal agreements and actually handling the data that goes through the contract. So we're just going to do kind of a quick overview of smart contracts and also show a quick demo of like how you can easily automate a contract that you upload to OpenLaw. Anything else you want to add, Michael?
No programming experience necessary.
Yes.
Excellent. Thank you. And is anybody helping Beth here? Anyone can speak to that interactive design upstairs? I'm the worst person to try to say it. Okay, there's a big thing happening. Can you say it?
I mean, she's going to show you how to set up a DAO in a really easy way.
Yes. And also, it's like immersive. Like she's set up this whole physical space where you walk around the space and answer questions, and it's a very cool, like she's kind of was like workshopping it is like what she's doing. Okay, so what's going to happen? So before we go forward, let me ask: is there anybody here itching to do a breakout on another topic? I remember last night we had some brainstorming. Were you raising your hand? No. Okay. So this is not the time to scratch your head, whoever. Do you want to do one? Yeah, come on up. Monax, who actually has a job description called legal engineers, so all hail.
Yeah, so if you want to see Monax, what we've been up to when people were talking about earlier user interface and to see what smart contracts, blockchain, permission network looks like without any of the crypto buzzwords in it, happy to walk through it, talk about it, tell you our hypotheses that seem to be coming pretty true. So yeah, I'll be upstairs and chat.
Beautiful. Okay. Going once, going twice. Any other people want to facilitate a breakout or a dialogue? Okay, good. So, so you've now seen the people that'll be facilitating these discussions. So over the next, 45 minutes with the pizza and until it gets here, I encourage you to kind of wander up and talk to people about the sessions that they may be interested in, and also talk to each other. And then once we get this pizza situated, we have a couple of interesting lunch talks as well, and that'll be happening down here. And then we'll have another panel or two, and then we'll all go upstairs where Beth has set up a bunch of little tables and stations, and we'll put little signs up so you can see which one of these conversations is happening at what table, and we can sort of self-organize. So any other questions at this point? Brendan? So it'll be down here, and our panel starts approximately the time that's listed on the website. Okay. All right, everybody. Pizza is here. Enjoy. Yay. That's good. Pizza.
All right, I'm gonna. All righty. Woo, everyone. We're gonna begin our lunch talk. Hopefully, there might be a bit more time for networking right after, or definitely later in the afternoon. So, let's have our presenter introduce herself. If you would like to continue your conversations, definitely, feel free above. But promise this will be an interesting talk, so I'd suggest you stay. So here we go.
So I introduced myself quickly before. So my name is Silke El-Rifai. I'm the Chief Legal Officer, General Counsel of Gnosis Group. I'm based in Berlin. We are doing quite a lot of different things, but one of the projects we are working on at the moment is we're creating a DAO. It's a DX DAO, and over the course of trying to find a legal arrangement for this DAO, and let me just check, does everyone know what a DAO is? A decentralized autonomous organization? Okay, so I'm going to say in a minute what a DAO is, but we're trying to do this code-based organization, and we had realized that there are a lot of legal issues. And the legal issues are usually, they come when there's a third party that is unhappy about it. So it's all about inter-DAO relationships. And most approaches, and we're going to speak about this in the next panel, is like looking at which jurisdiction has good grounding or good laws where we can like anchor the DAO. For this short presentation, I'm actually taking a different route because blockchain, as it is fundamentally unterritorial, and we shouldn't have to deal, or it shouldn't be the question that we deal with nation-state law. Maybe we should look at international law. So I just came back from DC. The American Society of International Law had their annual meeting, and I'm trying to gauge to see whether there's any chance we could get some kind of DAO principles or some smart contract principles into international law. And most of the people said, well, that's stupid, or that's absurd, or what you're saying. But there were quite a few even older members, very distinguished people, who said, yeah, you can pull this off. You can make it at least soft law. So what I'm trying to do is with you go through these principles, and it would be nice to have a kind of a discussion, and after that I'll take, or some other people, we will take care of trying to make this soft law in international law. So there were some people in the audience that weren't too familiar with decentralized autonomous organization. They've been around for a little while, quite infamous. In 2016, there was the DAO that was very, very successful at the beginning, and then there was a hack, and after that, you know, the community needed some time to regenerate and to build the basic infrastructure to make this happen. So this is a PDF, just because our machine is a bit broken. So let me just go down to explaining. So these are just 6 principles, which I would want to hope, and some other people would want to hope, and it's not just my work. We actually worked at the Koala workshop in Paris on this with 4 other people, including him. On like these principles, and they're not set in stone. It's just like, this is the first draft. So, but let me go through to how we're going to define a DAO for this principle so that we can start thinking about it. We thought that there are a lot of different definitions of DAO. Some say it's just basically a conglomeration of interacting smart contracts that simulate an organization, like a company or some other entity. Our definition is this. I really want your input on it. So a DAO, like a decentralized or distributed autonomous organizations, means a smart contract-based, hierarchical, distributed and trustless network that operates according to transparent and stakeholder-governed rules on a permissionless blockchain. Yeah. So there I need to say, this is of course not really suitable for computational law yet. So after we agreed this principle in plain English, we will then change them into something that's suitable for computational law. So this is a definition. I just wanted you to see, so in case people do not know what a DAO is, that they get a little bit more understanding about it. But to go back to this question is, how do you establish, so first we need to think about how do we establish international law? I mean, how do we get these principles in there? And there are different ways, but this is a very simplified version of how we're going to do it. We draft a written instrument, international instrument, setting out how we want the inter-DAO relations to be governed. So basically the DAO with third parties. That third parties can be governments, there can be other DAOs, there can be individuals. After we've done that, and that's what I would want your input in right now, we make it becomes soft law, you know. They're then frequently cited. There will be a commentary on those principles. There will be acceptance. States will look at it for their own legislation, and by that stage, so the more you talk about it, the easier it gets to make something soft law. And I think up to that stage, it is actually possible. And even the most, my 90-year-old former boss at the Yugoslavian tribunal, who's a distinguished judge, he said, well, yeah, I think you can pull this off. So we will get there. And then the more moonshot idea is hardening these principles into international law by incorporation in a treaty or state practice.
Can you say, like, for those that may not know, like, what is the Hague Convention? What's an example of international law that this could be part of?
It could be part of a treaty on how to deal with smart contracts, for example. So at this stage, we don't have any, we have different treaties, but not on smart contracts. There have been attempts to write an investment treaty which incorporated, for example, IOTA, but the people weren't too happy. So this is how it could get into international law. We could get an international treaty on this. But before we do that, normally it's easier to start this off with soft principles, which you can use as guidance. And that's what we're trying to do here. So we are at the stage one, the drafting. So at the Koala, Koala is the Coalition for Automated Legal Applications. It's headed by Constance Joyce and Primavera Di Filippi. They do these workshops all around the world. The last one in Paris, we worked on these principles because we kind of got fed up with looking at different nation-state law and how we could seat our DAOs there. So the first one, we need to define the scope of these principles. So the easier the better. These basic principles apply to the interaction of DAOs with their participant and third parties. And as you see, we've defined those three parties, DAOs, participant, and third parties. And that's actually the second principle. So it gave us a definition I had already looked at for the DAO, which I would like your input, whether you think we have there's a lot of space of improvement for this. Then the participant is defined as the controller of a digital public address. It would probably be an Ethereum address, which has the right to participate in a DAO that is a participant. And what are assets? Assets shall include on and off-chain assets. We've defined third parties very broadly. This could also be improved. Third party shall mean any person, including a natural person, corporate or unincorporated body, like a cooperative, for example, a government, state agency, whether or not they have legal personality. Because with the issue with the DAO is, of course, also that we don't get legal personality. We want legal personality for the DAO. We don't want legal personality for a company we are anchoring in the jurisdiction. What we are doing at the moment, most DAOs do this if they have a organization. Yeah, that is actually the point of those principles. We're trying to find something bigger than that. We think that there needs to be some kind of an identification of participants, so a DAO shall adopt an identification nomenclature of its participants, and that, importantly, that doesn't require nation-state adopted personal identification. It doesn't require passports. This is the most important provision. It's basically a DAO shall enjoy legal personality. There's still a question on whether this should be international legal personality. A DAO shall be liable for its obligations with its assets. A participant of a DAO shall not be liable for the DAO's obligation, and the DAO is not liable for the obligation of its participants. This is like, if we want DAOs to fly, we need to kind of limit liability, and at the moment it is through this anchoring mechanism, and we're going to speak about this in the next panel, actually. There'll be other topics, but that will be one of them. With those principles, we would like this to be understood internationally that the DAO isn't, that the participant isn't responsible for the obligations of the DAO, because in US law, in most of European laws, including German and French law, the situation is at the moment that the default option of a DAO is a general partnership. So as a general partnership, any participant could be liable and for the actions of a DAO, and well, that is a huge risk. If we want this to fly, this risk needs to disappear. And then the fifth principle, and these seem all really obvious perhaps, but not in international law. A DAO may have assets and may freely dispose of them. And the last one, participation in DAO is an opt-in voluntary process. When we started to work on this, there were many others, so like, okay, what should the members have? But this shouldn't be like, the easier, the more straightforward principles are, the easier it's possible to incorporate them into something bigger than the nation-state law. So we didn't consider it necessary to actually set out the termination rights or membership's rights in that organization, because this would be the DAO's terms of participation, not something like that. Yeah, so basically that those 6 principles, they were worked on with Anja Blasch, Martina Markesic, Professor Florence Guillaume. She's a very a distinguished professor in private international law in Switzerland, Constant Choice, and myself, and with the help also with Tim Banzema at the Koala workshop. So it's not just my work. Yeah, I'd like your contributions and ideas, questions, whatever.
So, questions? Well, first of all, round of applause, right? Pretty good. International law, it's getting real up in here. So, any questions or feedback? I think I'd promised at one point for Brooklyn Law current students would have first dibs, so why don't you get us started, and then you're next.
Thank you very much. I think it's a very good idea. The only question I have is, did you think that it would have also been important to, as a corollary to one of the principles, that the DAO can have assets and freely dispose of it, but it can also be obligated? No, like also be obligated, like if they were to take on a loan or some sort, that obligation lies with them.
Test 1.
Oh, wait, one sec. Hello? This is better. Yeah, so we thought about that, and we considered that because we give the DAO legal personality, they would be able to have obligations, and it's also, I mean, intrinsic in.
This is a little better.
Sorry, it's also intrinsic in our principle 4 that they basically have, the DAO would stand in. So, of course, the DAO, like, they interact with the real world, they're embedded in the on-chain world, and because of this, they can do harm to people. So it should be, at the moment, it's like every member can severally and jointly be liable. So it would be much better if the DAO that has, like, if it's on the Ethereum blockchain, you need to have some assets. It has assets, and it should pay with those assets for its liabilities, and not like the lowest hanging fruit. But that is, so you think it would be good to put that in a separate article? Okay. Yeah, no, this is a good idea. So basically, you say that a DAO can be obligated. Good. That would be a good amendment. This is being recorded or something, then I can remember this later. Oh, perfect. Then I can work that into the document. Yeah.
Are there any examples of already existing or projects that were leading up to kind of trans nation state legal entities? Like, is there a legal entity that exists now that is both legal within the U.S. and within another country? Or are the nation states the only actors right now regulating the types of entities, legal entities?
So what, in terms of corporate law, there are a few, you have international institutions that are on that kind of level. So, but that's also basically where the nation states are the actors and they created those institutions. I think for this kind of project would be more similar to kind of, I don't know whether you're familiar with the Hague rules or like the CISG, they all became, or like the Hague Principles on the Choice of Law. This is a good example. So the Hague Principles on the Choice of Law, they're not binding because they weren't able to find state support, so they couldn't agree on stuff. And so what the Hague Conference did was they produced these 12 principles. It's maybe double the length of what I just prepared, it's quite short, to have those be referred to in international disputes, and that's actually happening. So, but it's also on the stage, so they are probably like comparable to what we are trying to do. On the organizational level, I haven't seen it other than for international institutions that have actually international legal personality. So we try to do it, but this is, this project, this is more medium term. Like, international law is very slow.
Other questions? Okay. Like Phil Donahue here. Here you go.
Thank you. My name is Mongko. I'm from yeskoi.com, and I'm interested to learn more about e-identification that you mentioned. From what you have gathered with your working group, what kind of e-identification that you plan to use with DAO?
Oh, the identification. So we thought right now, for example, you could build a DAO and make it use a British, say UK company limited by a guarantee to kind of anchor it in the United Kingdom. Company limited by a guarantee doesn't have any shares, and for that you would need to put like the members of the DAO into like with their full passport names and everything in the thing. But for example, we are building the DX DAO, and for that, the membership is supposed to be fluid. We will have hopefully, thousands of people participating. They might just come in, come out, and we thought that there isn't a need for these principles to have real name identification, but that the Ethereum address for this purpose would be sufficient. So that is that was principle 3. So we said as a second principle that for DAOs generally, because what the liability is covered by the assets of the DAO, there is no need to have a real name identification, but they could do it if they want to, because they're different DAOs for different things. Sometimes you do it because you need it, because on a legal basis you might have to do KYC. But we thought in the system it would be sufficient to say that it's not required to have a nation-state-based identification system.
I understand that it's not required, but
yeah. How
do you prove that this is a participant?
Oh, the participant, any participant so the participant is a controller, the one who has the control of the Ethereum address that holds your voting rights.
So how do you handle one person who have multiple Ethereum addresses?
Well, then the person is a controller, it's still one participant because you're the controller of the Ethereum address, right? So we said that the participant...
So if it goes to voting and one person have millions of Ethereum addresses, does it have million votes, or how do you can?
But it depends on the DAO. So for example, it's not one person, one vote, right? Because different persons can have different voting stakes. So for example, in the DXDAO, your voting rights depend on how much ether you have locked in the system or how much you have traded on the Dutch exchange protocol. And based on that, you get, and the Ethereum address that takes part gets a voting right allocation. So you will still have, if you have 5 Ethereum addresses, you still have a participant as the controller behind it. At least this is how we define it right now in the principles. If you think we should change this?
No, how do you prevent bad actors to acquire, put a large amount of money and spread out to multiple Ethereum addresses and control DAO? That is, if you don't tie into personal identification that this is one person behind this.
But it depends on the DAO. I mean, my position is, maybe I might not completely understand your question. My position is that it depends what the DAO does, right? Of course, you have dark DAOs, and they do whatever they want. They don't care about being anywhere regulated. That do other stuff. But you know, on the DAO, I mean, it doesn't, for example, now again, speaking about a DXDAO, the voting rights are not transferable from your Ethereum address. So we set it up that way to basically for at least as long as we have, you know, the DAO, and then it's, you know, sent to the community, they can change this. But right now, you know, it's a kosher DAO. It does everything legally and without any. So we're staying clear from securities regulation. We like the reputation. We use DAO stacks framework, so they call it the reputation, the voting rights. They are just addressed to one address and you can't transfer it. There's no bonding curve to get your money or whatever it is. It's not even a value. Right? It depends on the DAO, what they do.
I would like to see is to expand on this area where it can, we hope to build DAO that serve good purpose, good causes for the society and the world. So if we can have mechanism to prevent bad actors to take advantage of the platform that we're creating would be great. Yes.
But do you think, I mean, the question in this regard is, do you think it is required on an international level to incorporate that into the principle? So basically your argument is that you want to have KYC in my principles, basically. What are my principles, the principles?
Could I take a whack at what I think you're saying? If I understand it correctly, it's a follow-on from your insight that it depends on what the DAO is doing. So it depends, but so far you've been articulating one set of things it could do for which KYC is not needed. Let's explore the other things that DAOs could do for which KYC may be needed. So maybe something in international law at a soft principle before drafting might be an acknowledgement that if the scope covers things that DAOs may do, that where one person, one vote matters, or we're tying it down to you're a voter in Brooklyn, or you're a resident in Brooklyn, that's why you participate in this city project-oriented DAO, or you can postulate other times when tying it to an individual or attributes about a single individual could be what the DAO does. Well, then maybe the international principle should also allow for that. Or the other way to go as a drafting principle could be to scope the international thing to say we're not dealing with those things, we're just dealing with this type. But addressing it somehow more explicitly, I think is what you're suggesting would be useful. Okay, and he agreed to that what I said is what he said.
So basically so you want to change the second one to the nomenclature may require nation-state adopted personal identification, but in other cases it does not, or something like that.
And that's right. And so now speaking on my own behalf as an identity geek for decades, I would actually parse it 3 ways. One is that sometimes it may not exactly as you're saying now. A second one would be it may require state issued ID, like, I don't know, could we do our passports or could we, vote or something like that on a DAO? But then the third one, which I think is most important, is when there's a source of personal identification, but it's not from the state. It comes from,
social media?
Well, you could do social media. You could do from your political group, from your union, from your community group, from some self-sourced type of thing, like with self-sovereign identity, but there's sources of valid, legit, like I sign most contracts DASA Greenwood. The government, that's not registered with government on my birth certificate, but it's the name that I go by, and it's certainly enforceable in contract. And so there's many sources of identity, naming, and other identity attributes that are not government issued, but they still serve identity purposes. And that would be the third category that you might consider allowing for.
Yeah, that's good. Great.
Do we have time? So let me just do a check. So we've got one more lunch talk on ISOC, and how many questions? One, Ori, and did I see another one? And a follow-up question. Okay, so let's do Ori first.
Hey, I had a question about the entity being liable for its debts, or liable. How does that make sense? Because there's no legal authority that can seize the assets of the DXDAO. So just saying that it's liable for its debts doesn't mean it will, or that it can be.
Well, I think enforcement at this stage would be again on the state level. So the idea would be that the states that have no laws on DAOs would consider that instead of going after the individuals, they would go after the actual DAO, because it's the DAO that has the assets. And because, I mean, you know, if you don't anchor your system anywhere, you do a DAO without a legal entity, you can be sued anywhere, basically. No, so this doesn't resolve any issue of being dealt with on the enforcement would be through, at the moment, and for probably a long time, on the state level.
Yeah, I'm just wondering if you have a DAO that's just like a multi-sig, that's 20 of 1,000 signatures need to validate every transaction, and someone lent the DAO, you know, 100 Ether, and then it's not paying it back. You can't compel that quorum from that group of signature holders to, unless you go after every single one of them individually and like seize their private key. I don't understand how the law could enforce the way it does with corporations liability.
I think it would probably be set up, it depends on the setup of the DAO. So if your DAO is basically a huge multi-sig, this would, yeah, you're right. Then what would happen is that the regulator, wherever, let's say the Mongolian regulator wants to go after the DAO, they would try to find someone, identify the person, have a tracing agency, go after them, see whether they have enough money. If they have a lot of money, they're going to go after. Yeah, so you still have that problem, but I think most, and maybe this is just my assumption, is that you have much more advanced setups now for DAOs. But that is a good point to consider.
Yeah, my statement was just in relation to the idea about principle 2, I think it was, which is about the identification. I don't think the principle itself needs to be changed in its language, because I think the second part of the principle, nomenclature, does not require nation-state adopted personal identification. Is sufficient. It is not necessary. It's not a necessary feature, but you can have it as a feature of a DAO.
Yeah, I think
Speaking of identity, this is Chris. This is not Steve. Sorry, as you were. Everybody's Steve in my book, I guess.
No.
It's a nice.
With the third, so I mean, the people who dealt working on this, they were very adamant that some of the people were very adamant that they want to have nation-state identification. But I think there's room to improve this and basically to have add other things or make this more precise and allow different scenarios, as Mongol also said. So yeah, I'll have the video of that so I can then work on incorporating all the stuff. Thank you.
So substantive. General Counsel of Gnosis, laying down the law. Okay, so thank you, Silke. We now have another quick talk from Jonathan Askin, and, well, you're Steve to me, I don't know.
Who's seen the DAO of Steve? Raise your hand. No one? Shut up. All right, we got a couple people seeing the
There you
DAO
go.
with Steve.
You might want to introduce yourself for real.
I'm not Steve.
A perfect integration of DAO and Steve.
I'm Greg Chatton. I'm the president of the New York chapter of the Internet Society. And Jonathan is on the board of the Internet Society New York chapter and also Brooklyn legal hacker par extraordinaire. So we thought we'd talk a little bit about the two organizations, what they can do for each other, what commonalities, differences. We have a nice banner here. It also tells you how to join the Internet Society. Anyone can join, but you don't know what it is yet, so why would you do that? But hopefully you'll know in a few minutes. And so I'll sit here and have a large blue light shine on my face.
So I want to say, I've been a member of the Internet Society for probably 20 years at this point. Legal Hackers has only existed, where's the gang? What, 8 years? 7 years? 2012, 7 years. The Internet Society always felt like my sort of policy home since I found out about the Internet Society when I was probably living in DC at the time. Legal Hackers has become my home in recent years. And it always sort of intrigued me, the possibility of a merger between the two, at least more collaboration between the two. The only time I've ever really seen the collaboration is in the form of Jolie here, who is essentially ubiquitous both in ISOC and Legal Hackers and has bridged the communities very well. But we've never really worked together on policy initiatives or other activities. And I want to, if I can ask you the first question, what is ISOC? What does it do? What's its mission?
ISOC, which is short for the Internet Society and should not be confused for iSocks, which are these socks right here with the Internet Society logo, was founded by essentially the inventors of the internet. Vince Cerf, Bob Kahn, other people who initially decided, that it could be cool if two computers could be joined together and talk to each other, which, happened not so long ago. And after they went off and did that, they thought, well, that has no conscience. Shouldn't the internet have a conscience? And basically, the Internet Society is the conscience of the internet. It exists to support the idea of a global, interoperable, open to everyone, permissionless, hopefully trustworthy, secure internet. The idea that the internet is for everyone is that's the elevator pitch. And if you think about it, an internet was probably inevitable. The internet as we have it today, a network of networks that is essentially not more than a handshake in many ways between all these different network operators and nodes that somehow underlies everything that we've been talking about in this room all day. That was not inevitable, but kind of the way it got its start and the way it kept going as something that's rooted in kind of certain set of principles is what the Internet Society supports, and then it does that in some very concrete ways as well, because it's not just a philosophy.
Okay, so in concrete ways, what does it do? I've been, for varying times in my connections with the Internet Society, we've tried to get involved in all sorts of different issues, policy issues, some technical issues, et cetera. What is your sense of what the Internet Society does, has done, and could do? Because that will inform it, to some extent, what goes on with Legal Hackers and what goes on with other folks in this room and how you can actually succeed as a global organization.
Sure, so the Internet Society is both global and local. There is the Internet Society, which is a global non-governmental organization which is headquartered in the United States, has its legal personality in Virginia, I believe. But in any case, that is a global organization. Then there are a series of independent chapters, which are kind of members of ISOC, but also have their own independent identity and sometimes have their own priorities that may be part of the ISOC priorities, may even be different. So ISOC New York is a 501c3 New York corporation that was founded in 1997. So it's older than ICANN, it's older than that dog probably, and, not older than me, but ISOC Global was founded in 1992, but both of them kind of exist to have priorities both globally and locally. So the big Internet Society is a reasonably well-funded professional organization, and ISOC New York is a unreasonably unfunded organization of volunteers and people who believe that the internet needs to be both secured and protected and coddled and also let off the leash. And so our priorities in New York are to really both a priority both globally and locally is community networking, trying to get more people literally connected to the internet. And that could be both in a refugee camp or it could be in Harlem. It could be in Brooklyn. There's actually NYC Mesh, which many of you may have heard of. Community network is kind of an activity that we sponsor and kind of provide an umbrella for. And we also deal with other sorts of connectivity type issues, but also deal with issues about security on the Internet of Things, secure routing, and the making of internet policy, and the idea that policy should be bottom-up and multi-stakeholder and driven by the end user.
All right, so I don't know if that's true. All right, I'm very active with the New York chapter of the Internet Society, and to me it's a bunch of very virtuous, hippie, techie do-gooders. All right, a lot of that's how I sort of feel when I'm in the ISOC New York community.
I would not disagree with that as kind of the expression of the current expression. Or
that's not what I feel when I am participating in Internet Society Global. All right, what I feel there, and this is where I think the disconnect is, and this is where I think those of us in the blockchain space, computational law space, legal hacker space could learn from what I think are the differences between local ISOC and global ISOC. Globally, ISOC, to a large extent, seems paralyzed in its ability to participate in policy discussions. That may be a controversial statement. I think a lot of the ISOC Global folks might challenge me on that, but I've never really seen ISOC Global get too involved in any policy issue that's politically charged or controversial. I feel like it's pretty easy. What?
Wicket.
Wicket. So Jolie, tell us about the Wicket. This may be the exception proving the rule, but we'll see.
One thing to keep in mind, ICANN is ISOC is what it can be called an ISTAR organization. It is a kind of a global organization that deals with other internet governance organizations, and this is an internet governance controversy. The
Wicket, Benny, remind me, is he here? Remind me what it's the World Conference on International Communication.
Information technology.
And so it's the ITU thing that they have every 20 years. It was the Wicket in 98 that in 88 that was the thing where they took down the rules which said that only government-approved people could lay cables between countries, which is what made the international internet happen. So there was one in now 2014, I think, where there's been this continuous struggle with the ITU to sort of take over the running of the internet and make it a top-down thing. And in fact, allied with McDowell, who was a Republican on the FCC, who first made the noise about it, the Internet Society led a movement which actually put a stop to this, worldwide, where they got the Americans on board, we've got a bunch of other countries on board, and managed to stop the motions going through that would have made that happen. But I will say that we have a very strong policy team. We have a strong policy team in Europe. We work on in Australia right now, there was they brought in the backdoor law. We campaign hard to try and stop that law. In India, right now they're bringing in similar kind of laws. We have our regional bureau in there is campaigning against those laws. There's we're working at very high levels at the OECD and other levels to try and change regulation on spectrum to enable community networks. There's all kinds of policy activity going on globally on the Internet Society. So I take issue with what you say.
And so I think that it may have less to do in the U.S. perhaps.
Which I also was a correction, which was, Greg didn't mention. He talked about chapters. But he didn't mention that we also have special interest groups. And this includes a blockchain special interest group. And in fact, and money flows from the Internet Society to the chapters and to the special interest groups through a thing called Beyond the Net. And in fact, we've just separated now, so there's a foundation which finances, you can get up to like $30,000 for a project, which in fact is what launched NYC Mesh in New York, was an Internet Society grant. There is nothing to stop you guys banding together and to make a law special interest group in the Internet Society applying for money to support what you do.
So a computational law SIG could well be a, and that would be kind of non-geographical if you want it to be, and it could intersect with the geographical organizations like ISOC, New York. So I think Jolie did set us straight there.
Well, so I think Jolie may well be right. I still feel like what the Internet Society for me has been a great community to have these discussions. So they have the blockchain SIG, they have all sorts of special interest groups that talk about very specialized issues, and it's a great internal discussion. I haven't seen too much of the fruits of actual policy advocacy from ISOC, and it may in fact exist. It may just not be on the issues that we've tried to get ISOC engaged in things like net neutrality, and we've been essentially stifled on those sorts of issues. Now, I'm mostly trying to flag this as a sort of as a background learning tool for the rest of us.
Neutrality. The thing is that globally, we've tried to keep the internet as an open, independent thing that's free of regulation as much as possible. So supporting regulation at one level domestically in America would screw us worldwide, because all these other countries would say, okay, well, you're for it there, so we're going to clamp down on it. So that's basically, we've got the wider view.
So when we first started Legal Hackers, our first ever legal hackathon was essentially a talkathon. It was all a bunch of lawyers, no technologists in the room, trying to figure out how we could do things, but not having the technical expertise to actually get things done. After our first hackathon, which I think was successful, we tried to branch out and figure out how we tap into the internet community, the tech community. This is how we actually tapped into folks like DAZA. We thought, where is there a world-class technology university that doesn't have a law school of its own that could be our tech partner on a lot of our legal hack issues? Yes, so DAZA got heavily involved and helped us build the global legal hackers community and build in some tech chops to it. I feel like Internet Society is another vehicle for us as primarily lawyers. It looked like the predominant, most of us were in fact lawyers, another community for us to tap in, not just to tech universities, but also into the global internet community through ISOC. So I thought when Legal Hackers we're now at 140 chapters around the world. How many chapters does ISOC have?
It's over 100. I'm not sure the exact number. About the same.
Oh, is it? I figured you had a lot more than us. But to the extent we have overlapping footprints and overlapping chapters, I feel like we should always be doing things in sync with ISOC.
I think it's good sense. I mean, ISOC, each chapter is grassroots where it is. They have different priorities. Outside the United States, the chapters are largely nationally based, although, especially where you have, so there's an ISOC Quebec as well as an ISOC Canada, so we deal with those things. But essentially, that's why there aren't more chapters, because out in the US, we have chapters in different cities, but outside, largely, there's one or two chapters in a country, and until there's a second chapter, the first chapter essentially represents the country.
So maybe my initial premise was wrong. It was that ISOC was emasculated and can't participate in global policy formation as an advocacy vehicle. I always had this concern that legal hackers might be similarly curbed from pursuing courageous policy initiatives, and should that be something we do? So here we're all talking about blockchain. We all probably come from different perspectives on the extent to which blockchain should or should not be regulated. It sounds like most of us are more blockchain libertarian than blockchain overseers, I guess. That might be a fair.
Well, in that sense, there is a commonality, as Jolie was mentioning. The idea is to be non-regulated, permissionless, and to find ways to work together, kind of across or ignoring borders, and without engaging kind of the power of the state, because the problem with the power of the state is, depending on the state, you may not like the power that it exercises. So I think in that way it's similar. And internet governance generally deals with the issues very much of how do you regulate or govern or keep hands off of something that essentially is everywhere and nowhere.
All right, I think we got to wind down. I should say, to some extent, I think a lot of us were probably internet utopians for many, many years. I think in recent years, some of us may have been woken up by the potential dark side of the web. I suspect the Internet Society is heavily involved in some of those issues. I suspect that many in the legal hackers community are also. I think, how much does it cost to join the New York chapter of the Internet Society?
Absolutely nothing.
So it's free. So is there any reason why someone shouldn't just sign up for the Internet Society?
Absolutely not.
All right.
So the way you join the Internet Society, and I'll take away the voice of God here, right there, internetsociety.org. I'll leave some materials on the back table where the pizza grease is. And basically, you go to internetsociety.org, you sign up, and then you can choose to join a chapter or more than one chapter or a special interest group. So I'd recommend everyone here should at least join the New York chapter and the blockchain SIG, and then look at other things there that might interest you, and get involved. The Internet Society New York chapter is basically what we make of it. It is not. It can support many things. It can contain multitudes. It can move in different directions. It can take advantage of the support of the global Internet Society in many different ways. And I think that it's really only limited by our own inventiveness and our own blood, sweat, and tears.
And for those of you who are not members of the New York chapter of Legal Hackers, that is also, as I recall, free? Absolutely free. Yeah. All right, so worth joining too. They're both good, to the extent the Internet Society works with the UN and ICANN and other NGOs and government groups. It's a great way to meet government officials, world government leaders, and to educate them on the issues of importance to us also.
Absolutely.
All right, Raina, any parting words? Who remembers the 3 laws of the Tao of Steve? Be excellent. Be, what's the second one? Be excellent. The last one is be excellent, be something, be gone.
And when you say the Tao of Steve, do you mean the Distributed Autonomous Organization of Steve?
I mean the movie.
Oh, okay.
Do you remember the second one? Be excellent. Be excellent. It's about it's a way to pick up women. You're supposed to be excellent in her presence. You're supposed to be something else, and then you're supposed to be gone, absent, so that you...
I think the 4 beings on this couch are not...
With that, I'm just trying to say we shall be gone now.
Yes, here we go.
Yay!
That was good. Thank you. So we've got a program announcement. Because we're a little bit behind, actual Steve Nam has kindly agreed to make what was going to be our last panel of the day one of the breakout sessions upstairs. So it's going to be all breakout after the next panel, and that's blockchain governance, with some interesting people coming in remotely. So Brendan Silk, could you come on up? So this is the last like kind of big group thing of the day before we, yes. Before we break into small group discussions and hacking teams. So come on in.
Thank you, Daza.
Thanks. Again, I think you know me already. I'm Daza Greenwood, for those of you that are new here. And this panel is on automated legal entities and autonomous legal entities. We're going to be digging deeper now into one of the international principles that Silk brought up. DAOs should have legal personality. That's another way of saying it should be like a corporation. Can sue and be sued, form contracts, hire people. So let's dig into that. Won't you join me on the couch area? Here's fine. I want to get us started, and then one of you go. So this will be mostly a discussion with people, we hope, but just to set the table a little bit. The question here is, how can software, like how can a DAO, for example, or other automated software, constitute a valid legal entity? So one of the principles was that it could be liable. In order to be for anyone or anything to be liable, it has to be a legal entity. So like a poem can't be liable, or an idea can't be liable. Like a script I just wrote in JavaScript can't be liable, even if it does something to incur that incurs liability. There's legal parties are required to be named in a lawsuit, and in order to be sued. So here's some of the questions that this has raised. If humans are in the loop for key approvals, decisions, or other actions, what aspects of the entity could or should be achieved through automated processes? So what's the relationship between humans and the software code? We have a concept that Silk just brought up of like a participant that has an address. Are there other roles that one could imagine? Another way to say that would be, if you looked at all of the functions and actions that a legal entity must take at minimum, must be capable of taking, like it has to be capable of signing something, it has to be capable of having process served on it, like a legal notice. Which of these functions right now can be or should be achieved by software, and which ones can or should be achieved through humans that are acting as agents for the software? Or the other way, and then I guess I'll say this, there's kind of three ways people have talked about this. One of them is that the software is sort of an AI, and it can contract with humans to act as its agents. The other way to look at it is you have humans that are like the board of directors, and they're operating through the software. So the company or the firm is software. And another way to look at it, which is going to be represented on our panel, is that the software itself should be a legal entity. That's a little bit edgy, but it's not unprecedented in the law. So for example, in maritime law, for various purposes, a ship has been considered a legal entity. If you look back in maritime law, that's not unprecedented. Obviously, corporations are considered legal entities. They're legal persons. And the other thing I was going to say is one of the outputs of this panel and of our brainstorming together is a continuing conversation with the National Association of Secretaries of State. That's a U.S. Organization where all of the elected members, where all of the members are elected secretaries of state. And in the United States, they're the statewide elected office that's usually responsible, almost exclusively responsible for forming corporations or LLCs. They're very interested in blockchain, and states like Wyoming and Delaware and others are doing some things with blockchain. But one of the questions that I'm talking with them about, and which may be on one of their future agendas for more discussion, and I've agreed to give Leslie Reynolds, who's their executive director, the notes and a link to this discussion as well, is what about the corporations division? Could there be a way where software could form a corporation? There's a certain amount of data that's needed. You have to fill, usually a human on a web form, fill out the name of the corporation, the name and address of a person to serve process, a registered agent, who's on the board, some things about the scope, if there's stock, what classes of stock are involved. You submit like $35 to more, in a credit card, and hit submit, and you get back, if all the fields are correct, a corporation with a number, and it exists in a registry that the Secretary of State maintains, like a directory of all the then current corporations. I think this is where we want to focus, at least part of the dialogue here is, as a real practical matter, can we hack some software? Can we build and rapid prototype some software in collaboration with friends at the National Association of Secretaries of State, at least the ones that raise their hand and say we want to play, we want to explore this, that would work hand in glove with their current web services that they use as an interface for people to form corporations and LLCs. We think we can, and we think by rapid prototyping something like that as a result of the dialogue today, we'll learn a lot more about whether we can do this now or whether there's a gap or some little wrinkle that we hadn't discovered yet, and that can feed back into be more requirements or design goals that we could then do a second version of the software to try to address. So with all of that as kind of context setting, I want to introduce first Brendan Marr, who's an MIT Media Lab alumni, and we also went to college together back in 1850 years.
Centuries ago.
Yeah, and Brendan, why don't you introduce yourself and then make the case for software actually being a legal entity.
Okay. Thank you very much, Dazza. Thanks. If I had the first words of my talk, I'd be all set.
Hold it up to your mouth.
There we go. Okay. So the first thing I want to say is that if you're following along...
A little closer.
Okay.
Yeah.
There we go. Wait, let me get the first word. I'll be much better. There we go. So this is going to be an action-packed talk. And if you're following the slides, I want you to know that later, anything I don't cover, we can cover later on the panel, or you can talk to me later on. So my name is Brendan Marr. I am an MIT Media Laboratory alumnus from 1998, and I have a lot of experience in these types of systems. Satoshi granted us proof of experience, and most importantly, proof of existence. He showed us that he is, let me say this again. Why did I botch that up?
Thanks.
So this is the story. So Satoshi granted us proof of existence, but he did not grant us proof of identity. Now this is a problem for automated and autonomous systems, because you can't sue Satoshi, okay? There is a bigger problem with automated and autonomous systems because they are something that can kill you, right? So what I propose is paying attention to jurisdiction. We want to have these things that are autonomous, have a jurisdiction, have them be registered. So my big proposal is that we have a consensus of risk, a consensus of safety risks, so that we take all of the things that are related to safety around these things, and we have consensus around them. Not just safety, but also their viability, right? Because we're talking about distributed and autonomous entities which have a life, right? So it could be viability in terms of their long-term livability. This relates to operational capital, right? You don't want these things to get stuck on a bridge because they don't have any money, right? So everything in that realm. There is another aspect to this, which is emergent dynamic law and emergent dynamic systems. Emergent dynamic systems and environments are problematic for automated and distributed systems, because we're working with contracts. We all know about them, the smart contracts. These contracts are deterministic. They are Turing complete contracts. They have loops that are finite. But what happens when you take an emergent environment and you have random things that can happen, right? They can make those contracts become non-deterministic, and this is a problem. If it rains, do this. If it snows, do that. But if there's a hurricane and you didn't plan for that, there's a problem. If this isn't autonomous or automated system that's a real-time system, then you can kill somebody, right? So these things are really important. So what you want to be able to bear mind to and you want to be able to do is to have a cryptographic representation or representations of these things. You want to have a reasoning about the safety of these things and their viability. You want to know that they have safety systems in place. However, you can't guarantee for sure mathematically that they are going to be safe, right? Because nobody could do that. But you want to know at least there's a system. So how do you do this? You have cryptographic representations such as multi-sig signatures that do proof of authority. You have hashing. You can do hashing of algorithms, hashing of data sets. This is not just related to autonomous entities, but it's also related to DAOs and governments and artificial intelligence. You can have zero-knowledge proofs. There's all sorts of different kinds of algorithms that we have now, that we will have in the future, that allow for this to happen in a deterministic way for non-deterministic events. You're all lawyers, and what I want to just remind and share is that this is not Excel. It's not Excel at all. This is the hardest part of computing. It's real-time systems. Lawyers tend to think in terms of clauses that are about the future and clauses about the past. But it's the stuff in the middle, the really hard stuff. Okay? Now, the good thing is that there's a lot of geeks out there that actually know how to do this really well. Okay? It's actually a relatively small subset. But they're the ones who are doing the autonomous cars and the rockets that can self-dock without human intervention. Okay? So there are people who know how to do this. Don't tread on the First and Fourth Amendment. It's really important. Keep your smart contracts simple. Make them so that they're relative to safety and also to viability. Don't get caught up in what will be a potential problem about infringement on First and Fourth Amendment, because this is going to play out over this next year and coming years. We're all in the same cubicle together, and quite frankly, computational law is exciting. And all the lawyers are now geeks. Thank you very much.
Thanks, Ben. Awesome. Great. So let's hold questions until Silk has said her piece, and then what we really want to do is circle up and have a conversation. So, Silk?
There are actually a few countries, or there's at least one country where I've seen that has given legal personality to smart contract systems, or what they call innovative technological arrangement. That's Malta. I don't think they've done it that well, but they've actually made an attempt at this last year. I'm not happy with the regulation, but I'd be happy to see other states to actually work on this. So the issue is why I'm not happy about what they've done is, so they've actually in their legislation, they passed 3 acts. One of them is relevant to this. Set out that decentralized autonomous organization or smart contracts are subject to this, so can be kind of be added to some register. And although it's not set out in the act itself saying this DAO or smart contract is going to have legal personality, that's what's basically it does. The thing is, how does it do it? It's using the old methods of what we already know, like the kind of traditional ways to go through intermediaries. So instead of having this in a lean new regulation where you have a self-owning smart contract or smart contract system or DAO, you have all these other parties that are involved in this. So you have someone is the applicant, who could be the designer or some other legal entity that needs to submit the application to be certified, to have this ITA, Innovative Technological Arrangement certified. Then you need some resident agent who looks after this. You need a technical administrator, and all these people basically are intermediaries that make that system very expensive. In addition, this technical administrator who has to be appointed has to have a backdoor to like a kill switch, an amendment key to the Innovative Technological Arrangement, and that's basically most of the things that are built in the space right now not really a good idea. So having spoken to the regulator, they have these guidance notes, and in those guidance notes they said, yeah, we just realized, okay, that seems to be a problem. A lot of the systems don't want to have this kill switch where the regulator comes in and changes all the things. So, well, maybe for some things you don't need it, so if the consumer protection doesn't require it, then maybe we'll consider not to have it. In addition, every time you make a change, so for example, we have given the auctioneering power of the Dutch exchange to this DX DAO. We're in the process of doing that. I mean, the point of doing that is that the auctioneer can change things. So if we were in Malta, we would need the regulator for every single code change you make to the system, would need to have an approval for it, which is a cumbersome project. So because of this, I think the Malta framework is being used. It is being used, but not as much as it could. It's super expensive. And I don't know that many projects that actually considered for this, for like a smart contract or DAO to be based there. But it's a good start, and I mean, they made an attempt to give legal personality to code, basically. So, yeah, there are other options. I don't think I should.
What are the other options?
So they are also.
I don't know all the details, but yeah, so I'm Danny from DAO Incubator in Pando. But after this technological arrangement law came out, there was the Max Ganado, who was one of the person who wrote this. He wrote the Ganado Doctrine. And so I don't know the details, but they are unveiling a fourth DAO law that will give also DAOs like a legal personality that is distinct from the idea of the technological arrangement, because it assumed agency on a person and not agency of the DAO on its own.
Yeah, exactly.
So I mean, I don't know what they're going to unveil. It's going to be in less than a month, but I know they are evolving on this framework.
So they're going to publish it within the next month, you say?
Yes. So it's going to be the Malta Blockchain Summit, and they're on the website of the event.
Yeah.
They said they're going to unveil it, the Prime Minister, whatever, during that. So, yeah.
There's a link to that paper on the. There's a link to that paper on the paper that I have associated with this.
Perfect. So if you go back to the event site, I'll add all of those links. All the materials are in our GitHub repository where the event site is, but look there for the links and also come up afterwards and ask for more information. What is going on here? I had to ask for feedback, but not this. That was awesome. Woo! Who wants to party tonight? Okay. So let's open it up now. Questions, comments. You first.
Thanks.
You want to meet me halfway? Okay, thanks.
So just as a bit of a background, I'm a corporate attorney who specializes in formation of new companies. And I tend to think that the ability to create a separate legal personality, at least in the U.S., is leavened by certain ways that the corporate veil can be pierced if the entity is used for evil. So if the entity is fundamentally undercapitalized or is used for some other bad purpose. And to me, that's sort of the natural trade-off. We allow people to create separate legal entities and limit their own personal liability in exchange for certain measures to actually grab at them if they misuse this particular legal structure. And I think that's fair. So, what mechanisms would you suggest to have fail-safes for situations where people use these legal personhoods for evil?
I can get us started on that. That's an excellent question. Do you mind holding on to that and handing it to
Yeah,
the
sure.
next person? Thanks. You're all deputized. So what was rattling around the back of my head when Silk gave the lunch talk and shared with us the international principles, including for legal personality for DAOs, the principle that a DAO should be liable for its own actions, got me thinking about what types of almost public policy trade-offs would be appropriate, and where would this liability allocation make sense in a more holistic legal framework. And what it called to mind was in the 90s, when public key infrastructure was coming on strong with the advent of wide use of public key certificates and certification authorities. I was active in the American Bar Association Information Security Committee, and we'd worked with the state of Utah and some other states to draft digital signature legislation that included liability limitations for certain parties, like the certification authority, for example, so long as it abided by its published rules for identifying a party and associating a public key with them. Well, it turned out we were too rash in creating legislation. It was too early, and we didn't fully understand how that market was going to develop, or what all the relationships and risks are, and how they could more fairly be allocated. One of the criticisms of that is what called to mind by a guy named Brad Biddle was, well, if you're going to limit the liability of a party or cause a party to be liable for something, there maybe also should be a concept of like a capital reserve. So for example, if one says as a principle, a DAO or other automated entity would be liable for certain types of actions, like let's just postulate for a moment that we provided them legal entity status. Maybe one of the types of circuit breakers could be, and it must have proportional insurance, bonding, risk reserve pool that's kind of commensurate or proportional to the risks that it is taking. That way people could have recourse and could be made whole again. So thinking about some of those types of mechanisms to ensure the fairness of a coherent and complete legal framework, I think is that's the work before us now. More or other comments on that?
Okay, great. Yeah, sure, I've got a few comments. One is that for certain things, you do want to have a registration and a kill switch. And this comes up, it's not just blockchain or finance, it's also in other areas, in other domains, biology, right? These are the same issues that we are facing in genetics. Kevin Elsflat is doing work with that, with idea and construct around gene drives, right? Having kill switches for biological entities. So these are the themes of the day.
And you're speaking to the like synth bio
Yes,
and like
that's correct, yes.
manufactured biologic entities, not the result of natural evolution.
Correct, yes.
Great. Other comments on this?
No, I mean, I wanted also to speak about the reserve structure. So basically, I mean, what you would have to have is for the DAOs, the moment you do this, the legislation would have to consider how to protect the consumers, and one way of doing that is basically through, for the entity to have sufficient assets proportionate to what they're doing. But it would be, I think we need to stop looking only at like the approach we've taken for years, which is going through intermediaries, and like the system has changed. It's just a different technology. It needs different solutions, and you cannot just do the same thing we've done before. So I think there should be self-owning contracts, smart contracts, or DAOs that have personality.
Great. Other questions or ideas? Yes?
I wanted to ask a clarification on the notion of the safety spell switch. So I feel like the argument you're making about like complex behavior coming from like basic atomic units, you could not only look at in smart contracts, but like in normal contracts. So like the basic atomic unit of the society is the law that then kind of creates this thing called society, which is chaotic and emergent. And we see this also applied, for example, this complex system design in the social management and social credit system in China. And I understand what you mean by having it being autonomous. It means it's like immutable and unstoppable and nobody can restrict it. So my question is that, are you advocating for a limitation of autonomy via this safety mechanisms?
Mr. Song, yes. That is an excellent question. And it really depends on what the use of these are. We don't want to get into a situation where we're micromanaging all the code, right? Because then we're treading on our free speech and the Fourth Amendment, right? Search and seizure. So there has to be a balance, okay? It's clear to me, and I wasn't a person who initially thought, oh, we should, have registration for things. I was actually against that. But then I started realizing that, once for certain things people start to die, somebody's going to say we need to register something. So we better start to think about this. But it's very important that we just don't blindly start saying that everything needs to be registered. Because the fact is that blockchains and all these technologies are software. And, that could be a problem for free speech.
Hey, Ori, I'm about to call on you just so you start coming this direction, but I think you're the next question.
Just to expand on this conversation, a corporation sometimes needs to be dissolved or needs to be shut down or wound down. Is there something built in? Because thinking of the kill switch as something, like something terrible is happening is one way, but there may be another where you may want to just decide as a group that you need to cease the functioning of the organization. So how do you do that?
Well, that's governance, right? No one said that these things don't have governance. The question is, for the governance they have, at what point is it registered? At what point is it centralized to a jurisdiction, right? And there's going to be lots of different forms of these things. I can make a club, and that club can be a decentralized organization. Am I going to have to register my club for the SEC or any other body? It really depends on what these things do.
Here. It reminds me, the first time I ever saw MIT Media Lab, Brendan and I were, we had clubs. You had the virtual reality club, and I had the legal interest group of Boston Computer Society. We teamed up to do a joint meeting, and we talked about VR and avatars and AI and law. And one of the ideas that came out of that session, when we were actually talking about this topic, like should they have legal personality? Should can these things actually be like legal entities? Was I think I had said, well, what if we had like a license plate equivalent on them? So we know what license plates are. We kind of know the role that they serve to connect an object now that can itself be autonomous, with autonomous vehicles, to a legal party, and there's a registry somewhere, you could do a lookup, but we don't regulate where exactly you can drive, but we have some proportional touch point to have a directory and to attribute the acts of hardware or software in this case to legal parties and to legal mechanisms like risk reserve pools or car insurance or whatever. Steve, just kidding.
Thanks, Greg Shatton. And I'm asking this with neither hat on that I had before, but as a participant in ICANN, internet governance, and especially dealing lately with the issues of the WHOIS domain registration database and the effect that GDPR has had on it. And so I think by analogy, the domain name registration database, which is a privately governed set of data that's collected each time somebody registers for a domain name, and which until May 25th of last year was basically open data, and then on May 25th suddenly became redacted for privacy on almost a global basis.
Right.
So,
but still available upon
96% have not even been responded to. The information is now privately in the hands of each individual registrar or registry, and most of them respond poorly, if at all, to most requests for information. And it's not at all automated. There's discussion now of an automated and accredited access model. That'll take about a year, year and a half, maybe, to resolve. But I think there's a lot could be learned, both good and bad, lessons learned from the conversation that's being had, the dialogue that's being had at ICANN around how you deal with the data governance of personal data that has been collected, in this case, over 20 years. But the challenge, the GDPR challenge is huge, and depending upon the stakeholders you listen to, global privacy is not only the most important thing, it's the only important thing, and who is a terrible idea, and nobody should have any access to it ever. Other people feel differently, but as soon as you start getting a lot of different stakeholders in the conversation, and remember the bottom line idea of GDPR is that the data belongs to the subject. Right. So you have a lot of issues here about how you actually can maintain databases of information on a private level, because GDPR does allow governments to collect all kinds of information that private organizations can't. So so that creates an issue for ICANN that say the New York State Department of Motor Vehicles does not have.
Got it.
So
just a quick check. I know you have a question. Who else is busting with a question?
So I guess my question is, have you thought about kind of the issues that come out of this and the kind of the interaction between GDPR and other privacy rules and collecting this data in a way that would be made available, and by whom and to whom and when?
I can speak a little bit to that, although I'd like to hear from others. Your question, and then I've asked Ori to come up to talk to us about a state statute in Vermont where they're already moving toward blockchain-based LLCs, and he's building a system that I think would be a good starting point as we get into our breakout groups. But some musings on what you just said, Greg, are number one, there is so I was an arbitrator for many years in the UDRP, which is the Domain Name versus Trademark Dispute Resolution process. So that would be an example that continues today, where if you're a accredited registrar, incapable of assigning domain names, one of the things you have to do is respond to this kind of very structured complaint process. If a registered trademark holder believes someone that's a registered domain holder is infringing their trademark, there's a form you fill out, and it starts this process. So that's not the same as a public registry where you can see the name and the telephone number and address of everybody, but it does respond to due process, and it responds to to a need to know. Same thing with license plates, actually. If you get someone's license plate and the insurer needs to find out who's responsible, for example, there's a process to do that without rendering naked everybody that's in the registry. But as you said, I think the most important thing is actually the other one I'd name is lawyers. And so I once I had a law license, for other public policy reasons that balance with privacy, it's felt that my name and my address and my current status of active practice, have I had any malpractice against me, those types of consumer protection notices, I have had no malpractice, were publicly available in a lookup. So I think there's several gradations, but what you're saying is very much essential to, I think, Brendan's main point, which is we have to have some way to register these artificial entities, and there has to be, and I think that should be a core component of our thinking going forward. That should be one of the design challenges that we try to solve for, and part of the way to solve for it is to address the wrinkles that you're bringing up.
The data governance up front really needs to be data governance by design that's built in, and not just privacy by design, but also access by design.
Amen. So I think you're next. Can you grab a mic from anybody? And who are you?
Hi, I'm Diana Stern. I work at Baker Hostetler. So I'll start with my questions. You can think about it, and then I'll give a little bit of context. So my question is, what do you think is a minimum viable DAO? So both from a legal perspective and a technical perspective. And from a legal perspective, I'm thinking of it like when you think of the downside of liability, and we can limit it to the US, if you're not proactive in setting up a structure and setting up contractual agreements, then you fall into that unincorporated partnership situation with nobody liked, because eventually if you can't collect from the DAO itself, you're gonna go to the people running the nodes or whatever. And then from a technical perspective, what's the minimum viable DAO? Like, do you start on a permission network, or like a permission network that other people can see so you have some accountability, like a public permissioned, or you just go like full Ethereum, or do you start on the test network of a public Ethereum? So I just would like to get some thoughts on kind of what is the minimum viable DAO from those perspectives.
So from a legal perspective, minimum viable DAO would probably be, I mean, just to understand your question fully, it's basically, you want to see how you can build a DAO which is legally compliant.
So that you avoid those worst case scenarios happening.
Yeah.
Like, what is the bare minimum we kind of need so that we're not worried about being sued as individuals for what the DAO does?
So the easiest way to do it, and it very much depends on the purpose of your DAO, and I think Beth is going to do a really nice workshop upstairs about this later. So you would want to have an anchor in a jurisdiction, because as I said, if you do not have an anchor, you can be sued anywhere on the planet, basically in any country, because they, via private international law, they basically draw you into your jurisdiction. So to make it the easiest, you would go probably for, you could, for example, as I earlier said, you go for company limited by guarantee in the UK. I think you have something similar here in the US, where there aren't any members. It's used usually for charities or cooperatives. You would then have the company register of this isn't public. You could put that on a blockchain. You just, the downside of that is, and I found this out only 2 days ago, is that you basically have to have a board. And of course the board can have liability. So what you want to do in that situation is have a D&O insurance. So I think this would probably be the minimum viable DAO, where you need an anchor through either a company or something. There will be some directors or board of directors or similar guarantors or whatever you use, and they would need an insurance. I think this would be the base. There's also another thing in the US which is really interesting if you want to do one here, is that through some bad legal drafting, you can actually create a 0-member LLC. So what happens is that the moment, it's possible that so they allow, and I'm really not an expert on US law, but they allow 90 days for you to have not a member in your LLC, but there's nothing after those 90 days to kind of struck it out. So you can just go on, you have a perpetual 0-member LLC, and that would be perfect for a DAO, I think. I mean, because the LLC owns itself because there's no member. I would assume they'd probably get rid of this sometime.
Well, and speaking of LLCs and blockchain, and what would be like minimum, maybe requirements and constraints that you'd want to build in at design phase, Ori's been working diligently on this, and you're as far along as anyone I've met before.
And I can answer quickly from the technical perspective. I think the minimum viable DAO is just a multi-sig. And so we already see thousands of these. And if you have a 3 of 5 multi-sig, it's a DAO. It's an on-chain decision process for budgeting funds and making decisions. So executing any arbitrary transaction on the Ethereum blockchain, for example. Even on Bitcoin, you can do, it supports multi-sig. So you can have a DAO on Bitcoin. And so you already see these like more complex protocols being built on Bitcoin just on the basis of convoluted ways of ordering multi-sig transactions. And then that kind of transitions into the project I'm working on, which right now we are just a multi-sig, and so we are operating as a DAO, but we realized really quickly that there's legal liability issues, like you're saying, we're all have like unlimited joint and several liability for all of the DAO's actions and its deaths. So the route we've been going is working with a firm in Vermont to stand ourselves up as a BBLLC, and then also transition to a more complex on-chain mechanism. So instead of just a multi-sig, having a DAO stack DAO be the back end.
And can you unpack
Yeah.
BBLLC? Like what's
Yeah,
going
so-
on in Vermont?
Yeah, sure. So I think it was in July, they passed a law that is called, well, part of it is the blockchain-based LLC. And the idea is that you could kind of, like Silky was saying, like just anchor your DAO or smart contract into the legal system. So what it would look like in practice is you'd have an operating agreement that just specifies a smart contract as the mechanism for distributing and changing ownership and governance. And so you just have a really, really lightweight contract on the legal side that kind of specifies who the administrative participant is, the person who's going to be served notices, who's going to pay taxes, who's going to have a mailing address on the books. And then that person doesn't necessarily need to have any claims on equity or special privileges that the potentially thousands of other members of the DAO don't have. So yeah, you can have an operating, and we're going through the steps right now, and so we're really right in the middle of it. So I don't really know completely how it's going to look, but we're designing it like very intentionally so that there's no like centralization vector, so that the linkage that the smart contract system has with the legal system isn't a vulnerability that compromises the autonomy, as Danny was talking about, of the DAO, so that a kill switch wouldn't be necessary. You would just have all operation, governance, ownership, decisions delegated on-chain.
Can I?
I just want to clarify one thing and then right back to you. So part of what Ori's talking about, and we have a version of it here that's marked up, and I think probably one of our breakout groups will be focused on this project that Ori's talking about. But you literally can go to the Secretary of State's office in Vermont now, and one of the types of LLCs you could select, based on this recently enacted statute, is the blockchain-based LLC. And among other, so there's one part of the workflow that I just want to highlight, which is these steps with the Secretary of State. You pay your fee to create and form the LLC, and you have some minimum terms in there, and we're just kind of going through the statute like over the last couple of days to see what those are. But there's the blockchain address where you could find the smart contract with the operating rules that are incorporated by reference.
The way that you change what contract you're pointing to. So maybe the contract itself could have mechanisms for swapping out which contract is the governance, or you could define in the legal process how you would switch from this multi-sig to a DAO stack DAO to an Aragon DAO.
Yeah, so I just want to highlight that. Follow up.
Yeah, so I'm curious, is the government doing anything to interface better with the technical aspects of what you're building? Like, messaging in different kinds of ways instead of like attaching documents to emails? Are they doing anything that's progressive on that front?
Yeah, not that I know of. The most useful thing they could do would be to have an Ethereum address for paying taxes, because then we can build a module to automate our taxation, so we can be tracking kind of our income and using the tax rates to automate the paying of taxes. Right now, you would need that administrative participant to then have the DAO vote to give the administrative participant the amount of taxes that the entity is due. And that's like a point of potential contention, that the DAO could decide not to pay its taxes, I guess. And so one thing you could do to prevent this, you talk about kind of designing systems so that they don't run into these problems, is that you could create like a module on the DAO or an additional like function or contract that is setting aside these taxes that then go to the administrative participant that they can then pay the state with.
Good stuff. Silk.
Yeah, I want to say something else to the minimum viable DAO. What you would also want to do is that the members, you need to set up, or you should set up in a contractual agreement for in that participation agreement he just mentioned, you would also want to have a dispute resolution mechanism for the members inside, because that's easy to regulate. You would want to have it to be a closed off system so that you don't. We have enough problems with third parties, so try to make it so that you don't have any problems with the other members. For example, you'd build in waivers, indemnifications, and like an arbitration system, which can even be on-chain, because there are now some on-chain systems. So I would try to also include a dispute feature.
An internal dispute.
An internal one. So that you have to kind of have only a minimum anchor to the state through like arbitration, where you can check, you can choose your rules of applicable law. You can often not do that in state law, and have an on-chain arbitration system that is enforceable in the real world, but basically make it closed off.
Yeah, and there's protocols out there like Claros that do peer-to-peer, which is probably what you're referring to, peer-to-peer arbitration. So one option is to have a function in your contract that, if someone claims that decision the DAO made was against its agreement with the DAO, that it could delegate to this arbitration network. Or if your DAO is well enough configured, it can all the arbitration can be internal to the DAO. Like you could say, if there's a dispute with the small decision making that happens, you take it to a majority or supermajority vote to the DAO to resolve the dispute. And that way you just, like you're saying, minimize the interfacing that has to happen with the legal system.
There's also reality TO and Claros and I forgot.
Aragon Court.
Arrogant, yes, that one is also very good.
And Dash does a lot of stuff.
Like a digital jurisdiction for all of the DAOs. And so from all of these DAOs, they randomly draw jurors, and you can basically upload a proposal agreement, which is like, these are the agreements we go with. And so you can basically contest exactly, it's kind of based on Claros, but the difference with Claros, that Claros is basically general. You can point it to any smart contract or escrowing, and this is for digital jurisdiction of DAO of DAOs. So.
DAO of DAOs. So we're just about to wrap up, but why don't we make this the last question? Can you grab the mic?
It's not a question. I made a
statement
on the legal end. So I can tell you how to
Can you say it into the mic?
Yeah, so I made a BBLLC on the legal end. So I can briefly explain how that works.
But can I ask, so the next thing we're going to do is break into smaller groups. So let's have a group, or maybe we can hijack slightly your group that you're doing with the DAP agreement. But I know some of us want to continue the discussion about DAOs and legal entities, but time doesn't completely permit. So can we put that forward to the breakouts? And let me ask, is there any final things that people on the panel would like to say? Brendan.
Sure. This is related to human in the loop. So there are times when human in the loop becomes necessary. Oddly enough, in my discussions with Beth, it turned out that thinking about these not from the life or birth of a company, but from the death is kind of useful, right? Looking at it in terms of bankruptcy and what happens when you reverse the process. So I'll leave you with that.
Right. Here for life cycle analysis. Okay, so let's, how about a round of applause for all the panelists? Nice. We're making progress. Okay, so now finally we all get to talk at once with these breakout sessions. Is there a wireless mic I can use? Where's a wireless mic? Okay, so what's going to happen now? Just as a reminder, let's just get a brief show of hands so we can get the right number of chairs and everything. So who here would be interested in the data as property?